Labrīt!
Good morning. Honourable Vice President of the European Court of Human Rights, Honourable Madam Minister for Justice, Honourable Chair of the Presidium of the Supreme Court, Honourable colleagues, dear justices, guests, ladies and gentlemen, it's my honour and a pleasure to welcome you to our conference that marks the 75th anniversary of the European Convention of Human Rights, which coincides with the 30th anniversary of our restored Senate or cessation court. The theme, the right to fair trial, European Convention on Human Rights and Dialogue of National Courts, and the ECtHR is very important. And right to fair trial is one of the fundamental rights, a very significant right in the architecture of the human rights. Without the right to fair trial, no other rights will be effective. It's a procedural right that provides the basis for everything, and that's why it is essential for any country ruled by the rule of law. It is the cornerstone of any system of rights. And in our system, cessation court, or the last court of appeal, is equally as essential. It provides for the uniform case law and, in fact, has the last word in all disputes, and therefore Supreme Court plays an enormous role in securing these human rights as the last bastion of those rights. And today's conference actually marks both of these important milestones. Now, as regards to the court dialogue is the very topic that we are going to discuss today, in particular focusing on the dialogue between national courts and European Court of the Human Rights, which has been around for decades, and some time has passed, so we can take a stock of how well we have done in terms of this dialogue. There was time when justices thought that the European Court of Human Rights is a limiting factor, is a hurdle, and quite often justices, when discussing, referred to or said, what will the Court of Human Rights say if we do this? Will they consider that this is probably too much? And quite often this precautionary stance led to very safe, from a case law perspective, judgments that in particular circumstances would have probably required a different judgment. However, this restricting or limiting factor was real, and quite often today I hear from justices that they are not looking for new reasons or new justifications, and are rather safely falling back on those precautious judgments, although there was no reason for such an approach. However, for the development of the laws, it is important to have diversity of views. However, the subsidiarity principle that has been stipulated in the preamble of the Convention shows that the European Court of Human Rights is not a watchdog. It is an equal partner in this dialogue, which basically means that the application of the Convention very much relies on national courts, or primarily depends on national courts, and European Court of Human Rights only steps in, and we in Latvia don't like this, but it comes in as a special or specialized court. But it is indeed a specialized or special court because of its role that provides a qualified opinion or an assessment, which means that national courts must evaluate how they protect the fundamental rights, which also requires to develop our approach to how we apply laws in courts. Only through disputes, only through differences, then we can arrive at an eventual solution. If there is no difference in opinions, then no development is taking place. And I could refer to a recent case in particular, a case in which Latvia benefited from a very, very valuable judgment. I'm talking about Gaponenko case, and the European Court of Human Rights recognized that although, generally speaking, in case law, the repeat offense shouldn't be referred to as the cause of the arrest or the detention. However, in this particular case, Latvia is in a specific geopolitical circumstances. It is neighboring with Russia, which has launched an aggressive war. And therefore, the court gave a sort of a new direction for the development of our laws and our rights, which is absolutely important in given circumstances. So through dialogue, open and professional dialogue on specific issues, we can develop the laws based on the context and the actual circumstances. European Human Rights Court and National Court dialogue is not a dialogue between a lower and higher court. It is there's no subordination. There is no right or wrong opinion in this dialogue. It is a dialogue between two equal partners, where instead of status or hierarchies, only arguments shall prevail. And also talking to colleagues in Strasbourg court, I quite often hear that they are to a greater extent relying on the opinion of national courts, or judgments rather, of the national courts that apply the standards and the provisions of the convention very scrupulously, with great scrutiny and precision. And that is why it is very important to ensure that our judgments are well justified, and that's why the quality of our judgments is the primary focus of the judicial council and the courts, because the right to fair trial, among other rights, depend on that. And also, with the adoption of the protocol, this dialogue has intensified. The fundamental rights and conceptual issues are being debated through the communication between courts directly. For example, right now, European Court of Human Rights reviews roughly 2 national requests regarding the convention interpretation. Latvia is also among those countries that can also ask for the different rulings, preliminary rulings of the European Court of Human Rights. And 16th protocol was recently also adopted by our parliament. So within a couple of months, we'll be also able to refer those requests to the European Court of Human Rights in a couple of months from now. Let me now focus on challenges. We are living in a very turbulent social political situation, or as ancient Chinese saying says, we're living in an interesting time. Now, the political populism is on the rise globally. That said, we see that there are attempts to downgrade and push the courts aside, and attempts to trivialize the case laws, and there are even attacks launched on the independence of courts in some of the European Union member states where such a thing would be unimaginable some decades ago. That has actually taken place. For some time, the legal scholars have been talking about the political fatigue, or the voters' fatigue, or election or electoral fatigue, and the same can be said about laws, and we can even talk about the rule of law fatigue, which is a dangerous phenomenon, in fact, which means or shows that people are losing trust in rule of law. Why? Well, there are several reasons for that, and rather complicated reasons for that. Low quality political discourse and big gap between statements and deeds, and also the regulatory overload, and such regulatory overload also overloads or pushes your comprehension to its limits. And nowadays we fully understand that a judge who's not specializing in specific cases can not work, with all kinds of cases, and also under the pressure of enormous backlog of cases, this has become even impossible. And a neutral application of this term can even devalue this term. And rule of law, I mean, we are overusing it, and rule of law is also used by those who attack the rule of law, or courts rather, because they refer to a rule of law to justify their attacks, and that is what we are witnessing. But that doesn't mean that we should forget about the rule of law. Rule of law should be at our focus, but we shouldn't be talking about it only in terms of statements. We need to attach an action plan to these statements, and we need to provide solutions. And only by showing people that we are able to solve current challenges, people will have trust in rule of law and will have the confidence in courts and will support the independence of the judicial branch. And I'm absolutely certain that our conference contributes to the understanding of the rights and will provide solutions for our current challenges. Wish everyone a very constructive and interesting discussion. Thank you.
And now I give the floor to the Vice Speaker of the Parliament of Latvia, Zanda, KALNINA-LUKAŠEVICA. Highly esteemed President of the Supreme Court, highly esteemed Minister for Justice, Madam Vice President of the European Court of Justice, judges, representatives of the judicial power from Latvia, from Europe, from European countries, dear all. Thank you for this invitation to attend this very important conference. To stand before you and to address you is a true honor for me. Today we convene here not only at a symbolic moment, but also at a time which is important for democracy and human rights. When I received this very kind invitation to address you at this conference dedicated to the 75th anniversary of the European Convention of Human Rights, I could not even imagine how relevant this matter would be at this moment here in Latvia. And indeed, 75 years ago, when the European Human Rights Convention was signed, it was 1950. The year was 1950. Consequences of the Second World War, so human suffering, mass deportations, genocide, and authoritarian regimes had left deep scars in Europe. At the end of war, it was clear so that these totalitarian crimes would not happen again, we had to create common internationally binding mechanisms for protecting human rights. The main task of the Council of Europe, established in 1949, was to promote democracy, the rule of law, and respect for human rights in Europe. And indeed, West European countries gathered in this organization, which tried to create one uniform democratic space. And being inspired by the Universal Declaration of Human Rights of the United Nations, which was adopted some years ago, and also inspired by the constitutions of European countries, the very intent of the convention intended something more. The aim was to create a legally binding treaty of countries with very specific mechanisms that would allow persons to defend their rights vis-à-vis the state and outside the borders of the state. And I would like to remind of this historical background, which is well known to all of us, because it seems that the world has walked in circles. And now we are at a moment, at a stage of history which is as significant. Ladies and gentlemen, we cannot deny that currently we live in times when rules-based international order is being contested. The challengers of the existing order are Russia and China, and they have stated the time has come to look for and find under their guidance a new standard for human rights provisions. And it is estimated that their offer might be ready in the coming 5 years by 2030, and we should get ready for this. Why so? Because it is a very clear priority for autocrats to the east of Latvia. China is actively and systemically, especially in the United Nations, trying to change, to transform the international system of human rights. It is trying to construct alternative standard of human rights in the face of China, human rights in Chinese taste. And I'm afraid that we don't have any illusions regarding the principles on which these standards would be based. Or possibly the concept human rights would be renamed as the right to be subject by the state power. And we should not be surprised if someone would start also contest and challenge the significance and meaning of the European Convention of Human Rights. In Latvia recently, we also hear those narratives of the eastern neighbors. The Convention Against Domestic Violence is contested. The work of civil society is denigrated, as well as democratic principles. And the values of the Constitution and European values are juxtaposed, although these are values that respect human rights, and these are our common values. So the coming years will show whether we will be able to preserve and consolidate the universal provisions of human rights, or we are going to lose what was achieved. We have to be aware European standards in human rights today are not self-evident. They are as threatened as in the darkest period of the 20th century. We see that the shadow of authoritarianism is spreading across Europe and the world. That's why human rights, as well as general principles of democracy, should be protected and reinforced. And because of these reasons, you judges have an important role in this fight. To record the content and meaning of human rights in your rulings. With each and every judgment, the court affirms that human rights and the rule of law are not empty words. Dear participants, recently, the world, Europe and Latvia face different new challenges, including spread of disinformation, development of technologies, including artificial intelligence, hybrid threats, instrumentalization of migration. These matters not only polarize society, but also pose challenges for the judicial system. These are not only political or technological issues, these are issues of human rights, because all of them test how alive our belief in human dignity, freedom, and the rule of law is. In such moments, the court system must prove its resilience and also loyalty to the principles of human rights, because the judicial system is the one that is able to record these. In such situations, borderline situations, the principle of a fair trial is very important, because even under general pressure, it should guarantee that human rights are not forgotten and that everyone can trust in an independent court and fair judgment. And that's why the Human Rights Convention should be alive. It's not a static exhibit of a museum or a document or a 75 years old document once written and printed in history books. Now, convention is a user's manual regarding democracy to be used every day. Ladies and gentlemen, the Convention on Human Rights has been in effect in Latvia for almost 30 years. This time has been long and dynamic for our state and also for the Latvian legal system. 1 year after Latvia joined the Convention, the chapter on human rights of our Constitution was adopted, enshrining human rights on the constitutional level and linking these with the Convention. And the Convention became directly applicable for Latvian courts. During these 30 years, the importance between the European Court of Human Rights and national courts has developed dynamically, and it plays an important role in reinforcing the common values and responsibilities of European countries. And that's why it is important to highlight signing of the 16th Protocol to Convention, This allows the Supreme Court and the Constitutional Court of Latvia to receive advisory opinion of the court. And also interpretation of the courts. As Mr. STRUPIŠS already said, I'm happy that yesterday our parliament voted on ratification of this protocol. This step will not only promote the dialogue with the European Court of Human Rights, but also will allow improving in general the system for human rights complexion and to deal with in better quality and due time all the matters related to human rights. And to conclude, ladies and gentlemen, esteemed representatives of the judicial power, we cannot assume that existing and good things are self-evident. Democracy should be protected and reinforced. Some try to crush it. Also, the freedom of election should be protected and reinforced. There are those who try to steal it. And the framework of human rights should be protected and reinforced. Some try to re-examine it. During the last 75 years, the European Convention on Human Rights has been very stable pillar for democracy. And today, after 3/4 of a century, we see that defending these principles has become the task for our generation. Human rights are our fundamental values and the foundation of security, and they will exist until we, the courts, the states, the public institutions, all together guard them. And that's why the conference of today is not only marking an anniversary of an important document, it's a possibility to look at the current reality in Latvia and the world, and to reaffirm once again, to have human rights in the future, we have to protect them today, to ensure that our democracy and our state exists today and also in the future. Highly esteemed President of the Supreme Court, judges, today we have convened here to mark another important event, restoration of the Senate of the Supreme Court 30 years ago. That was a symbolic event which also testifies to the past of the Latvian courts and efforts to create a just state and a state governed by the rule of law following the end of Soviet era. And that's why I greet you, the judges and the court employees, all of you who have worked for these 30 years to maintain the rule of law. And I would like to wish to you and to all of us to see that human rights and a fair trial remain as undisputed values in this country where the rule of law serves the people. Thank you. And now the floor is given to the Minister for Justice, Inese LީBINA-EGNERE. Highly esteemed President of the Supreme Court, Vice President of the European Court of Human Rights, Vice Speaker of the Parliament, Presidents of the Court from Estonia, from Lithuania, judges of the European Court of Human Rights, of the Constitutional Court, senators, judges, Ombudsman, dear colleagues. I'm also honored to stand here before you as the Minister for Justice of Latvia. And first of all, I would like to greet you. We are all celebrating today the 30th anniversary of restoring the Senate. Senate was of the very first institutions of Latvia, a symbol which was created in 1918 and shaped the backbone of the Latvian judicial system. And now, in this anniversary of restoration, we can indeed look at how it reflects the continuity of the Latvian state. When after restoring our independence, we restored also all the main elements of our judicial system. And currently, the judicial power in Latvia is strong. The judicial power is independent and we act to develop it, all of us, by joint effort. And today we are also celebrating the anniversary of the European Convention of Human Rights, the 75th anniversary of the convention. We know that, unfortunately, Latvia needed 45 long years in order to join the convention as a free and independent state, because initially this possibility was denied to us. The state which had its awareness of its values and had its institutional memories of the time before the Soviet occupation, all this was pulling us back, if I may say so, back into the space of European rule of law. And today we are and we shall be part of it, and we will remain such. And we are actively involved in developing the rule of law. The human rights system of the European Council, Convention, courts, and all the implementation mechanisms, we are actively involved in shaping them, and they always have had and will have decisive importance. And it also determines why we may call ourselves a democratic state governed by the rule of law.
We've gone a long way. We've faced numerous challenges as a judicial system in general, as well as different branches of power. But we are looking into the future with quite a lot of optimism. We are looking at the future where we, democratic European member states, will stick together. We will have to be real allies in order to overcome all the challenges to the legal system and political systems. And dialogue is absolutely essential in the proper functioning of democratic society. We have to remind it ourselves time and time again. And it is a dialogue between different branches of the government, courts, international courts, which is also an essential element in this development. That's why I'm so happy to welcome so many esteemed judges from international courts here today, from other courts of the European Union member states, and also international organizations. We are building bridges between our countries and organizations to arrive at the common understanding. And thank you for being here in Riga and devoting your time to strengthening these bridges through this discussion during this conference. The topic of a right to fair trial has always been at our focus, and as previous speakers already mentioned it, in today's circumstances, it is even more important. Today we are facing existential threats. You know, existential is a very, very strong word, but we are facing existential threats to our democratic system governed by the rule of law. There are external threats, but there are also internal attempts to undermine this system. And when it comes to domestic politics, populists always want to arrive at quick solutions and propose quick solutions. It's like a full moon behavior, as we call it. But if we systematically work with these issues, then the internal populism will have very little room to, in fact, influence how we operate. By targeting rule of law and often playing on the stigma popular in the society, and also relying on the potential of disinformation from outside, as we can see, this is all very clearly orchestrated by a country aggressor. And the objective is to instrumentalize illegal migration, for example, or irregular migration, rather, and also play on the homophobic and other issues, sensitive issues that are important to the society. And it is very easy to, in fact, drive a rift between people and convince people that probably stepping away from the human rights principle is not so bad, and the attempts to eradicate the rule of law and international order, rules-based order, attempts to eradicate rules-based order and substitute it with interests instead of values is a straight road to hell. And Russian aggression against Ukraine is an attack on the values, the notion, the idea of rights being subject to legitimate restrictions. And there's also in internal regions is a bit more quiet, but devastating nonetheless. Human rights are being reduced to the value of, or to the notion of alien doctrines. An intolerance towards a judicial process is disguised under the, or disguises the ideology that attacks the judicial branch. And here in Latvia, for the past years, we've managed to withstand these turbulences and face these challenges. We have to, however, be united. We have to remain strong and face these challenges and turbulences ourselves, because nobody will come to save us if we won't. And democracy is not just the will of the majority. It is the will of a law. Democracy is the will of law, and we are ruling the majority through law and protecting minorities' rights and individual rights through democracy. And rule of law is the very safeguard of the democracy and human dignity. And speakers before me have already underlined its importance. Without this, neither the rule of law or the courts will be able to function properly. And you judges make the law a practice, and without applying the laws, it will only remain a word on paper, and you are converting the laws into actual decisions that concern particular individuals. And rule of law steps in when other courts, other instances fail. You're the last instance that protects people against injustice, and that's why the independence of the court should always be inviolable. And today, we have to realize that we are not living in the rule of law peacetime, and as Mr. STRUPIŠS mentioned, we have the rule of law fatigue. We are, in fact, living at the time when our society needs the capable courts capable of quickly responding and precisely responding to new challenges that require us to implement self-defending democracy principles or militant democracy principles according to what circumstances around us. And the society expects the judicial branch to act as a power, not just an executive branch, but as a power that sets the limits. And that's why it's important for courts to be independent. We need to strengthen the independence of the courts, but not only because the courts need to be independent, but because they bear the accountability for the decision of each judge, for each ruling, which of course shape the confidence of the people in the rule of law and the courts. And only this way we can strengthen the democratic institutions and democratic power, and only that way we will make our countries resilient towards different challenges. It is obvious that judicial branches constituted not only by judges, but also the legislature and executive branch must also strengthen the judicial branch through different mechanisms available to it. And we have done a lot, in fact, already, and further strengthening of the confidence in judicial branch and the state as a whole requires common effort, and a lot has been done in dialogue with European courts, the European Court of Human Rights, and the effective application of the convention also depends on how well we deal with it. And by convention, we understand all the human rights mechanisms or all the human rights schemes that have been adopted by the European Union Council. The Convention and the European Court of Human Rights is the mechanism. It is the tool, not just the paper. And that's why it is absolutely essential for the democracy in Latvia in particular. And we need to be part of all of these schemes, all of these mechanisms. We need to be part of all of these conventions and all of these wonderful clubs or groups, or families rather, that strengthen these values. It is obvious that when dealing with different cases in courts, cases against Latvia in particular, European Court of Human Rights to a large extent relies also on the decisions of the national courts, opinions of national courts. We're appreciated. We're quite often consulted, as the subsidiarity principle requires and as convention requires. There's a close dialogue between the Latvian courts and the European Court of Human Rights, dialogue on how to uniformly apply human rights and human rights standards throughout the European Union. And such dialogue happens not only when the cases are reviewed, but also when the judgments are being made. And we also have to provide our feedback to the European Court of Human Rights on how we implement their rulings, and that is a responsibility of also executive branch and legislature as well. So national courts and European Court of Human Rights are in dialogue, which has led us to indeed very obvious, very apparent progress on understanding of the geopolitical circumstances we're in and Latvia is in, and we quite often can warn the others about what is ahead of us. Due to historic reasons, Latvia has always, when the need be, relied on the state continuity, national constitutional identity. And that's why all of our judgments very clearly and explicitly communicate how the case law of the European Court of Human Rights has been taken into account when making judgments at the national level. We highly appreciate European Court of Human Rights and its supervision in a way, or monitoring, because it allows us to take a look at ourselves from a distance. It is a prerogative of a mature democracy to allow others to assess us, evaluate us, and accept the assessment done by the outsiders. And if you take our statistics, we have 94% of cases closed, cases that end up on in front of the European Court of Human Rights, which means that the majority of cases that are referred to the Strasbourg Court have by the court been recognized as sufficient in terms of Latvia conducting a full review of the particular case, which means that our capability to efficiently safeguard the human rights has been recognized and has been appreciated by other member states and European Court of Human Rights in particular. And of course, there's a lot to be done. There's a lot still ahead of us. There are, of course, gaps that still need to be bridged, but Latvia has implemented a lot of ECHR case law. The ECHR case law has, to a large extent, contributed to the development of our national court case law when it comes to the protection of the fundamental rights of our citizens. It has been one of the major sources of the case law, and these case laws don't remain only on paper. They are being implemented, applied, and the application of those case laws will always be the measure of our democracy, rule of law, and our power as the judicial branch, and it has always been a priority of the executive and legislative branch as well. Sometimes populists doubt the necessity of international legal mechanisms, and at the moment we are amid an experiment, and this is not an internal sort of domestic policy issue. That's an external experiment, an experiment that challenges the Convention against domestic violence and the monitoring mechanisms provided therein based on common values and the protections of the fundamental rights. And the European Council procedures established for the monitoring. So this convention is challenged without any rational or legal arguments. This is not just a sudden phenomena. Sometimes it is very valuable to reevaluate things, to take a look back at what we have achieved, but it is equally as important to look outside the box and try to understand what we as a country could lose if we are not a part of this monitoring scheme, and if we are not supporting the values of our allies, and if we are not part of this family of values. And in order to strengthen this dialogue, Latvia this year not only signed the 16th protocol, but as Madam Vice Speaker and Mr. President of the Supreme Court already mentioned, it was approved by the Parliament in the final reading yesterday. So now we expect that the 16th protocol will be applied, will become operational, will provide wider opportunities for our people as well. And each such a step, when people actually see how human rights protection mechanisms or schemes benefit them, strengthen their confidence in the necessity of such mechanisms and need to protect them. And also the Judicial Academy, newly established, that will be actually open next week, is our common contribution to stronger judicial system here in Latvia, to better understanding, a greater awareness how important it is to be more united, more integrated into the European family of courts, European Court of Human Rights, Court of Justice of the European Union, and also the constitutional values of the other EU member states. I would like to also underline that we have also improved greatly our prison infrastructure. Although that might be only a prerogative of the Ministry of Justice, I nevertheless truly believe that that is one step towards stronger rule of law. We've improved the conditions in our prisons, our prison infrastructure, and are trying to implement the standards of those countries who support the same values. Ladies and gentlemen, I do apologize for taking so much time in my opening remarks, but on occasions like these, we not only have to focus on the nice words, but really, think about why we are here. And we are here because we can do a lot. And let's not forget about how much we can actually do together. And what we together can do in terms of overturning this big enemy that we have, or adversary that we have. And this is indeed the time to be very much united.
Thank you, Madam Minister. We are slightly behind the agenda, and we will change a bit the planning because Madam JELIČ will have to go to the airport in order to go to the sitting of the Venice Commission. And that's why I will now give the floor to the Vice President of the European Court of Human Rights, Ivana JELIČ, and keynote speech, Interaction of the European Court of Human Rights and National Courts.
Thank you, Mr. President of Supreme Court, Judge STRUPIŠS, Deputy Speaker of the Parliament, Ms. KALNINA-LUKAŠEVICA, Minister of Justice, Ms. LÍBINA-EGNERE, Mr. GUÐANS, Judge Zimele, Presidents of National Courts of the region, and also esteemed colleagues, judges, ladies and gentlemen. I'm genuinely honored and grateful to speak today in front of distinguished speakers and participants of the conference on the occasion of marking two significant events. One, for the Supreme Court of Latvia and entire Latvian judicial system, the 30th anniversary of the restored cassation instance, the SENEF, and another one, the 75th anniversary of the European Convention on Human Rights, significant for all Europeans. I'm glad to address you as a representative of the European Court of Human Rights in capacity of its Vice President and President of Section 1, where the cases against Latvia are decided mainly. I would like to thank cordially to the President for his kind invitation and warm welcome, to my esteemed colleague, Judge Artur Skut, who in capacity of national judge elect in respect of Latvia serves as a liaison judge between our courts and contributes, if I may say, diligently to already excellent cooperation with superior courts of Latvia, our judicial partners. I would also like to thank the staff of the Supreme Court for excellent organization of my visit that happens in one of the busiest periods of the Strasbourg Court. And despite our almost hectic agenda these days, it is my great pleasure that the court from Strasbourg is represented by 3 judges. Today, as my esteemed fellow Judge Peter Rozma, elected in respect of Estonia, also takes part in this important event. When put simply, the central goal of the Strasbourg Court is perhaps self-evident. We aspire to guarantee the enjoyment of human rights for all individuals throughout Europe. Yet, this is not a task that we can accomplish alone. The Strasbourg Court has neither the mandate nor the operational capacity to act as a Supreme Court for entire continent. Instead, we rely on national courts of European states to play their own critical and complementary role in protecting the human rights of those under their jurisdiction. Cooperation and dialogue with those courts is therefore of utmost importance for the achievement of our ultimate mission. This has only become truer in recent years as Europe and the world face new and sometimes unprecedented challenges to human rights, as already mentioned by previous speakers. The COVID-19 pandemic, climate change, aggression and armed conflict in Ukraine, and widespread concerns to the crisis of the rule of law and evident democratic backsliding in some countries are but a few examples of contemporary obstacles which have threatened the states, the unity and coherence of European human rights system. Today, my focus is on the profound and evolving relationship between the European Court of Human Rights and national courts, with particular emphasis on the right to fair trial. The right to fair trial, guaranteed by Article 6 of the Convention, is more than a procedural guarantee. It is the cornerstone of justice and the keystone of human rights protection. Without fair judicial proceedings, the very architecture of rights collapses. No freedom can be effectively safeguarded, no dignity effectively defended, unless individuals are assured access to impartial tribunal, equality of arms, judicial remedies are both timely and effective. This guarantee enshrined in Article 6 of the Convention is perhaps the most litigated and most interpreted provision in Strasbourg Court jurisprudence, and rightly so. It is the gateway right through which all other rights may be claimed. The European Court of Human Rights and national courts are partners in dialogue, and that's why we are here today. From its inception, the European Court of Human Rights was never intended to operate in isolation. The Strasbourg Court is not Supreme Appellate Court above 46 national judicial systems. Rather, it functions with the Convention partnership. The national courts remain the primary guardians of human rights. They are the first port of call, the institutions closest to the facts and to the societies they serve. Strasbourg intervenes only subsidiarily, ensuring that states honor their commitments under the Convention and that individuals are protected when domestic remedies fail. This relationship is best understood not as hierarchical, but dialogical. Through judgments, advisory opinions, and interpretive principles, the European Court of Human Rights offers guidance. National courts, in turn, apply and sometimes even shape Strasbourg jurisprudence. It is iterative dialogue. A genuine European standard of rights protection has gradually emerged. What is the essence, the essential context of the right to fair trial according to the Strasbourg Court jurisprudence? Before exploring the interaction between courts, I would briefly recall essential dimension of Article 6. Access to court, the guarantee that no legal claim or defense shall be excluded arbitrarily. Independence and impartiality, tribunals must be free from external influence, both institutional and personal. Equality of arms and adversarial proceedings. Each party must have a reasonable opportunity to present its case under conditions that do not disadvantage its vis-à-vis the opponent. Reasonable time. Justice delayed is justice denied. Public hearing and reasoned judgment. Transparency in justice fosters legitimacy. Legal certainty and enforcement of judgments. A fair trial is meaningless if outcomes are ignored. These are not merely technical rules, but living guarantees, each shaped by decades of Strasbourg Court jurisprudence, each designed to preserve public confidence in justice in Europe. What is the role of national courts in giving effect to guarantees of Article 6? The Strasbourg Court cannot adjudicate every complaint. This is not our mission. The Strasbourg Court receives tens of thousands cases, applications annually. The bulk of responsibility lies therefore with national courts because the responsibility is shared. Across Europe, national judges have increasingly integrated Strasbourg standards into their own jurisprudence. Many constitutional courts, Supreme Courts, Supreme Administrative Courts, and even ordinary courts of the first instance now refer explicitly to the European Courts of Human Rights case law. For example, the UK Supreme Court and the German Federal Constitutional Court have both engaged in detailed dialogue with Strasbourg, sometimes aligning closely, sometimes cautiously asserting national perspectives, but always within the frame of mutual respect. Similarly, courts in Central and Eastern European countries, once new to the convention system, have rapidly internalized Article 6 guarantees, relying on Strasbourg case law in fields ranging from criminal proceedings to administrative justice. This reflects a crucial reality. The legitimacy of European Court depends not only on its own jurisprudence, but also on the willingness of national courts to embrace and apply it. There are certain tensions and challenges in this dialogue, and we are aware of that. Of course, the interaction between Strasbourg Court and national courts has not always been free of tensions. Marginal appreciation, overburdening of Article 6, backlash and resistance of some countries. National courts sometimes argue that Strasbourg Court defer more to domestic understanding, particularly in complex or culturally sensitive matters. Regarding overburdening of Article 6, with thousands of cases alleging unreasonable delays or procedural flaws, some judges fear that courts risk micromanaging national judicial systems. Regarding backlash and resistance, at times judgments of the European Court of Human Rights have been met with political or judicial resistance, raising questions about the limits of supranational authority. Yet, even in the moments of friction, the Strasbourg Court's case law demonstrates a readiness to engage constructively. For instance, it has developed doctrines of subsidiarity, shared responsibility, explicitly recognizing the primary role of domestic courts and recognizing them interpretive space within convention boundaries. Now I would like to refer to some landmark judgments illustrating this interaction regarding Article 6, which was shaped and being shaped by this dialogue. Golder versus United Kingdom. The court established that access to court is inherent in the rule of law. The judgment was swiftly integrated into national systems, influencing procedural reforms. Piersek versus Belgium and Decube versus Belgium. Here, the Strasbourg Court developed the objective test of impartiality. National courts across Europe adopted their standards of judicial recusal accordingly. Hosby versus Greece. The court held that the right to fair trial includes the right to enforcement of judgments. Scordino versus Italy. Addressing excessive length of proceedings, the court spurred legislative and judicial reforms in Italy and beyond. The Baltic states have also contributed significantly to convention dialogue through important Article 6 cases. Ilavens versus Latvia, concerning a lengthy and politically sensitive criminal trial. The court found violation due to excessive delay and doubts about judicial impartiality. This judgment prompted reflection within Latvia on judicial independence and case management. In Harkman versus Estonia, the court condemned proceedings lasting over 8 years, underscoring that unreasonable delays undermine justice. Estonia subsequently introduced reforms to accelerate court proceedings. In Jāsuņīne versus Lithuania, the court held that prolonged civil proceedings breach the right to trial within a reasonable time, highlighting systemic issues in Lithuania's judicial system. These cases, together with others such as Sorokin versus Latvia, Bakauskas versus Lithuania, show how Strasbourg jurisprudence has served as a catalyst for reforms in the Baltic region. Encouraging improvements in judicial efficiency, impartiality, and fairness. We are talking about the cases 20, 25 years ago. And now we witness the progress, and we are truly thankful for this cooperation and mutual trust. Right to fair trial in contemporary challenges. Article 6 faces new and evolving pressures. Digital justice and artificial intelligence in courts. How can fairness be guaranteed when algorithms assist in sentencing or case allocation? Transitional justice. In an interconnected Europe, cases often span jurisdictions. Ensuring fair trial guarantees across borders remain complex. Public trust in justice, perceptions of bias, delay, or opacity in courts risk eroding confidence in democratic institutions. Democratic backsliding and the crisis of the rule of law is evident danger for the basic European values, including peace, and Strasbourg jurisprudence showed its reply to this mostly in the cases regarding Poland and Hungary, but also some other countries. Here, the Strasbourg National Court partnership will be more vital than ever. No international court can answer these questions alone, but together, by integrating the principles, European principles into domestic law, Europe can craft responses that remain faithful to human dignity. I believe that the future will be dedicated to deepening judicial dialogue between Strasbourg and national courts. Looking ahead, 3 priorities seem essential. Strengthening judicial trainings. Both judges and lawyers must be equipped to understand and apply Strasbourg jurisprudence in daily practice. Promoting Protocol 16, wider ratification and use of advisory opinions will enhance structured dialogue and prevent violations before they occur. I was very happy to hear yesterday that the Parliament ratified Protocol 16, which actually gives new opportunity to superior courts of Latvia to request advisory opinions from the Strasbourg court for pending cases. Those advisory opinions are not compulsory. They are not judgments or decisions. They are only our assistance to our colleagues at national level, and they should be taken as our, so to say, assistance and cooperation, and not in any way any dictate. The third point is using the Superior Court's network to enrich dialogue between the Strasbourg Court and Constitutional and Supreme Courts and Supreme Administrative Courts of Council of Europe member states. And the fourth, safeguarding independence of judiciary. No fair trial is possible without independent courts. Strasbourg has been vigilant in this regard, but aware that domestic judges remain the frontline defenders of their own independence. Ladies and gentlemen, let me conclude. The interaction of the European Court of Human Rights and national courts is one of the most remarkable international legal endeavor and maybe experiment of our time. It is not always smooth, and it is never static. But it is precisely this dynamic and constructive tension, I would say, this dialogue that ensures that the Convention remains a living instrument, responsive to the needs of modern societies. The right to fair trial lies at the heart of our cooperation, for it is in the courtroom, perhaps more than anywhere else, that human rights are either vindicated or denied. And it is through the shared efforts of Strasbourg and national courts alike that Europe strives to make justice not a promise on a paper, but a daily reality of people. Let us therefore continue to nurture this dialogue, to cherish and deepen our cooperation, and reaffirm our commitments that every individual in every corner of Europe shall enjoy the rights to fair trial, protection of his or her dignity, the very foundation upon which all other rights rest. Thank you. And now, before leaving, as the President said, I have to represent my court at the 35th anniversary of the Venice Commission. Before I leave, I have a pleasure to, on behalf of the European Court of Human Rights and the President, Matthias Guillaumard, who greets you all and congratulates to Latvian Supreme Court, to hand over a small gift, like a token of appreciation from our court to the President and from the people. I will open it. I would like to open it and to show. This is something new that we made for 75th anniversary of. And also notebook.
Thank you. It has been duly accepted and will be safely stored in the vaults of our Supreme Court, where we keep our valuables.
Thank you so much. Thank you. All the best, and I wish you a great continuation and a fruitful discussion. It was my pleasure.
Tā, un tagad atgriežamies pie parastās darba kārtības, un nākamajam vārds ir.
And now we return to our official agenda, as it were, and would like to give the floor to one of the people who's behind today's event. As has been already mentioned, today we mark the 30th anniversary of the Senate of the Supreme Court as the final instance of the Court of Appeal, or the Senate, and it is my pleasure to now give the floor to Andris, the former President of the Supreme Court, who actually led the restoration of the Senate of the Supreme Court as the cassation court. Thank you. Honourable Mr. President, Honourable Madam Minister, Honourable Vice Speaker, Deputy Vice Speaker, pardon me. Dear friends, I could continue my remarks in many different ways, but I'm very happy to see many former colleagues of mine in this room, many familiar faces. A lot of fond memories are shared with you, and also I see less familiar faces, although they are not really unfamiliar, but, you know, there are many new faces among justices. So congratulations on the conference, and congratulations on being here. Welcome. And I was supposed to focus on history in my speech. So in order to make you smile, I want to underline that I've been here a couple of years ago in this very room, but it was a dance event or dance night back then. And I'm not saying that this is the room that is not suitable for conferences. I mean, it's lavish and posh enough for that. And I, of course, have my own fond memories from the dancing nights of this room. But nevertheless, I do believe that this conference in this very nice room, in this very nice atmosphere, will be very successful. European Convention of Human Rights in dialogue of national courts and the European Court of Human Rights. That's the very topic that we're supposed to discuss here today, and we are going to discuss it at great length today. Of that, you should have no doubt, but my remarks today will not be directly linked to the topic of today's conference. I will rather sidetrack and will probably bring you back into the history of our court. I think it's very important to know, you know, where our family comes from, figuratively speaking, but how also, you know, our institutions like Supreme Court originated and were restored. It's worth reminding it. Today or rather this year, we mark the 30th anniversary of the Supreme Court, the plenary decision to restore the cassation instance, or the Senate of the Supreme Court. Over these 3 decades, the Supreme Court has gone through many transformations. It has become a modern European court. And over these 3 decades, it has fully, and maybe I'm mistaken, but fully all of the justices have been replaced. So there's a new generation of justices. We are using new tools, new approaches, and over these 3 decades, a lot of things have already slipped from our memory and have faded into the obscurity. That's why it's important to look back at the main milestones in the history of our court. Each generation in each historic period has its tasks, specific tasks and challenges that it needs to deal with, and our success to a very large extent determines the future of our nation. 30 years ago, it was important to rebuild from scratch the cassation court, or the final instance court, as part of the judicial branch. But it was equally as important to make sure that this court has the necessary intellectual potential, or capacity rather, in order to respond quickly to the tasks ahead of it at the time. I'm absolutely certain that the generation of justices that shaped and later on led the Supreme Court did so in good faith and to the best of its conscience. And we can safely feel proud about what we have achieved, and we can safely say that we reached our goals. In my remarks, I would like to briefly again sidetrack and focus on some other important historical events and facts that are very important for our country, our court, and actually go a way back. After the proclamation of independence of our country on 18th of November 1980, there was a temporary decision or procedure on courts and trials establishing three-tier court or judiciary branch, including cassation, the court or the Senate of the Supreme Court. The date of the founding of the Senate is the 19th of December 1918. So that's the official birthday, more than 100 years ago, in fact, almost 110 years. Senate gradually became the actual Supreme Court and contributed greatly to the establishing of legal practices and development of legal thought and national laws. A lot of judgments of the Senate were available publicly and were published also in international publications and are still available to this day. Unfortunately, our independence fell to the Soviet occupation, which brought oppressions and a lot of damage to our country, and the Soviet rule closed the Senate in 1940 on 26th of November. A lot of senators were detained, arrested, and executed later by shooting. A lot of them fled the country and had to spend the rest of their life in exile. Only one of the exiled senators, Senator Andris, after exile, in fact, returned to Latvia and in 1963 died in Riga, or perished in Riga. Therefore, Soviet occupation completely destroyed the Senate as part of the independent judicial branch of Latvia, and it exterminated the judges as this living link to the Senate, connecting us with the legal thought of the time and the legal practices and culture of the time. These are probably the darkest pages in the history of the courts of our world. Probably our colleagues and our guests from Lithuania and Estonia share similar sentiments and similar stories from their history, and they know perfectly what happened to their judges after the occupation by the Soviet regime. Now, let's talk about the restoration of independence. It required a lot of, bold decisions, courageous decisions. In 1991, on 4th of May, Declaration on the Restoration of Independence of Latvia was adopted by the Supreme Council of Latvia, and we had to restore a lot of things back then, including also courts and laws. Since 1990, the Supreme Court restored its functioning as the Supreme Court of an independent state. It dealt with the judgments of the first instance courts in criminal and civil cases. At the time, it was important to decide whether judges, who worked for the Soviet Union and were educated in the Soviet Union, should be allowed to practice. It was a complicated decision that needed a political intervention or consideration, and as a result of that, we created a procedure that allowed for the independent evaluation of each judge, and as a result of this evaluation, a lot of judges stayed in profession, and the individual or case-by-case judgment was rational and the right choice, according to me, and I hope that many of you will share this opinion.
It gives a possibility to retain the core of judges of the Supreme Court. We have to admit there were people dissatisfied with it. The fact that the judges from the Soviet times continued working in independent Latvia. However, this decision could be influenced also by other external circumstances. because the community of judges and lawyers was not very extensive. And there were no lawyers who had acquired their knowledge outside the Soviet school. However, since the community of lawyers was small, it also had some positive dimensions to it because we all knew one another very well. That made assessment easier because we had sufficient information about every candidate for the position of a judge. We knew how they had worked, their judgments were available, and so this gave us the confidence to take valid decisions. Initially, the questions regarding the skills of a judge and the ability to master new law and apply according to new requirements advanced by new social economic processes and changes in the categories of cases, as well as the judicial reform embodying human rights and other matters. All these were relevant at the time and, of course, caused certain problems. Another aspect which also influenced trust in the judicial power and also trust in the judges of the Supreme Court. There were doubts regarding their loyalty to the Latvian state. But these doubts were not valid and these were not evidence-based. This was proven also by several plenary sessions of the Supreme Court, the general meeting of the judges, and several decisions by this meeting, which were adopted before independence was declared and can be seen as very independent and very far-sighted and courageous. I will refer only to one. In 14th of February 1991, the plenary session adopted the decision stating that the office of a judge is not compatible with affiliation to political parties and societal organization. This decision was mainly targeting the Communist Party to eliminate its impact upon courts. Also, in the following years, when judges and senators were fulfilling their duties, there were never doubts regarding their trust and loyalty to the state of Latvia and laws. When the judicial reform was implemented, the appellate and cassation instances had to be created from anew. However, even if we say from anew, this does not mean that we had to start building these institutions in an empty space. Although these institutions had been abolished during the Soviet time, we still had the historic memory about the judicial system of independent Latvia. We had the laws, for example, the civil law, which is still valid, also decisions of the Senate and other documents, which proved to be very useful at the time in this process of restoration and creation. And yet, new legal basis was needed for implementation of the reform. On the 15th of December 1992, the law on judicial power was adopted, and Section 43 states that the Supreme Court consists of Senate, the cassation instance, and 2 court chambers, in the appellate instance. This provision entered into effect following very thorough preparatory work, and also after the amendments were introduced in procedural law. Only at the end of 1995, we were ready to transit to the 3-tier judicial system, and on the 3rd of October of the same year, against the plenary session of the Supreme Court, according to requirements of the law, decided on on approving the composition of the Senate and court chambers, establishing cassation and appellate instances in the Supreme Court, and creating the structural model which functioned until 2014, December, when the Chamber of Criminal Cases was liquidated, and also civil chamber. And the Senate, the Supreme Court, turned into cassation instance, pure cassation instance. Later, also the Department of Administrative Cases was established as a new but no less important cassation instance of the Senate. Now, returning to the events that took place 30 years ago, but and I was also a witness of these, and I would like to share my findings, my reflections on how this happened. On the one hand, we are saying the plenary session convened and established the Senate, but before that, there was, I would say, emotional process going on, and I will try to reflect it as I remember it. If I'm mistaken, I believe there are people in this hall who were also participants of the events of those times. But I don't see many former judges among you. I'm not going to reveal anything sensational, but I believe that it was quite challenging and also interesting to participate and to observe the process, which, well, also individually, but it affected the whole community of judges and the life of judges. It was quite unique, unprecedented, and perhaps nothing like that would happen again in an individual's life. But it was also very responsible and affected the professional career of each judge. Before the decision was taken on establishing cassation and appellate instances, all judges of the Supreme Court were in the same situation, I might say. They were neither higher nor lower. And only as a result of democratic election, without any kind of administrative or political intervention or any kind of pressure, relying only on one's own ability to assess objectively ourselves and our colleagues, we had to take the decision, a professional decision, on who of the judges would continue working on the Supreme Cassation instance and who in the appellate instance. I think this was not an easy task to do, to assess oneself and also others, and to take this decision, which was really impacting the further careers of judges. And how to admit that before the final vote, there were discussions also about the assessment. It was an internal process. But finally, there were no disputes. Quite surprising. At this point, it might seem that this couldn't happen, but we had no disputes, and the decision was taken quite unanimously and without frictions or disputes. Perhaps there were colleagues who felt unappreciated, who were dissatisfied with the outcome, but all in all, as the time showed later on, the decision was correct. And now, looking back to these years, I would like to thank our colleagues who were involved in this process. I can be very proud in saying that this was a very wise, well-considered and objective decision. which really also revealed the maturity of the decision makers and the way they respected the national interests. And I'm very happy that this work of developing appellate and cassation instance continues, also through a dialogue and closer ties with international judicial institutions, including European Court of Human Rights, national courts, and the European Court of Human Rights are in united legal system. And this dialogue also facilitates development of courts. Each dialogue should have some kind of aim and result, and it can be attained if the parties involved in the dialogue speak in a reasoned way and in a common language. I believe that we are on the right path of development, and this conference will facilitate improvements to the legal thought and case law of the Senate, and also the dialogue that facilitates attainment of these goals. Thank you, dear colleagues, for your attention, and I wish you success in this conference. Thank you. So we have concluded our introductory part, and I am inviting now here to the stage the participants of the first panel. But before that, I would like to thank all the participants of the introductory procedure for their kind wishes and for their introductory words. Thank you. And so, for the first panel, moderator, a senator of the Department of Criminal Cases of the Supreme Court of Latvia, Anita POļakova, Peter Rosma, judge of the European Court of Human Rights, Chief Justice of the Supreme Court of Estonia, Villu Kove, and Senator of the Department of Administrative Cases of the Supreme Court of Latvia, Zanda America. And I now pass on the mic to the moderator of this session.
Labdien, kolēģi!
Good afternoon, dear colleagues. In this first panel, we're going to take a look at how rights to fair trial are being provided through legal certainty and the judgments and the justification of judgments. And dear speakers, unfortunately, I'll have to be harsh. You will have to limit your speeches to 15 minutes. And when you will reach those 15 minutes, I will use the bell. Unfortunately, I'm forced to do so because of the delay that we're in. To share his opinion on the aforementioned issues from the perspective of the ECtHR case law, we have the pleasure of having the European Court of Human Rights Judge, Peter Rosma. Please, the floor is yours.
Thank you very much. And I would like to start by thanking very much the Supreme Court of Latvia, its president, for organizing this conference. I hope it will lead to many interesting discussions and exchanges. But since our time is limited, I will go directly to my topic. My presentation will reflect on the requirement of reasoning of judicial decisions in the practice of the European Court of Human Rights. The expectation that courts provide reasons for their decisions is a cornerstone of any fair legal system. There are multiple reasons for that, and I will highlight only some. A reasoned judicial decision lends more legitimacy to a court, enabling the parties to understand why the case was decided in one way or another, and thereby also making it easier for the losing party to accept the outcome. Reasons enable the parties to exercise their right to appeal in a meaningful way. More generally, reasoned decisions form a part of the law of the land, and they clarify the meaning of the statutory law, put the flesh on the bones. As the European Court of Human Rights has put it in the lawfulness context, many laws are inevitably couched in terms which to a greater or lesser extent are vague and whose interpretation and application are questions of practice. Reasoned judicial decisions enable everyone to understand the actual content of law and to adjust their behavior accordingly, possibly avoiding disputes and any need to go to the courts in the first place. This aspect of the requirement of reasoned decisions is intertwined with the requirement of case law certainty. From the general perspective, reasoned judicial decisions only serve their function or the purpose if they form a part of the body of coherent and consistent case law. Now, the European Convention on Human Rights does not explicitly name the right to reasoned judicial decision. However, according to the long-standing practice of the European Court of Human Rights, the right to have a reasoned decision is one's case forms part of the fair trial guarantee enshrined in Article 6, paragraph 1 of the Convention. This means that judgments of courts should adequately state the reasons on which they are based. The extent of the duty to give reasons varies according to the nature of the decision and must be determined in the light of the circumstances of the case. A detailed answer to every argument advanced by the parties is not required. What is required, however, is to give parties to the proceedings a specific and explicit reply to their arguments, to these arguments which are decisive for the outcome of the proceedings. In cases relating to interference with the rights secured under the Convention, the Court seeks to establish whether the reasons provided were automatic or stereotypical. I will now go to some examples in some specific types of cases. In addition to the general requirement of reasoned judicial decisions, the Court has developed some specific requirements concerning reasoning in particular type of cases. First, as concerns the proceedings before the higher courts, provided that the first instance court has delivered a properly reasoned judgment, the court has applied less demanding requirements in respect of higher levels of jurisdiction. Thus, in dismissing an appeal, an appellate court may, in principle, simply endorse the reasons for the lower court's decision. In leave to appeal proceedings, or in preliminary examination by the superior courts whether or not to accept an appeal for examination, Article 6.1 does not require the superior courts to give detailed reasons on all arguments. For example, the court has accepted as sufficient that such an appeal is dismissed by reference to the relevant legal provision, as having no prospects of success or because the ground of appeal relied on was not such as to warrant admitting the appeal. A separate question arises in respect of requests for preliminary reference. Article 6.1 does not guarantee as such a right to have a case referred by a court for a preliminary ruling to another domestic court, such as Constitutional Court, or to the Court of Justice of the European Union. However, questions may arise as to how such refusal needs to be reasoned. As concerns a request for preliminary reference to a constitutional court, first, the domestic rules of procedure apply, and second, if a party to the proceedings raises a constitutional issue of importance for the determination of the case and requests that this issue be referred to the Constitutional Court, the domestic court has to provide specific reasons justifying its refusal to refer the question. For example, depending on the domestic law, again, the European Court of Human Rights has accepted that the ordinary courts exercise certain discretion in dealing with issues of constitutionality raised by the parties. But a well-reasoned and pertinent request by a party to the proceedings is dismissed in a summary fashion without duly providing reasons for refusal. There may be a violation of the right to have a reasoned decision. This is particularly so where an applicant's plea relates to the rights and freedoms guaranteed by the Convention, in which cases the courts are required to examine them with particular rigor and care. As concerns requests for preliminary reference to the Court of Justice of the European Union, a third legal system, the EU law, additionally comes into play. Similarly to national law, the European Court of Human Rights is not competent to apply or examine alleged violations of EU rules. However, in certain circumstances, the refusal to grant a request for referral may infringe the fairness of the proceedings. This may happen where the refusal is arbitrary, that is, where there has been a refusal even though the applicable rules allow no exception to the principle of preliminary reference. It may be also where the refusal is based on reasons other than those provided for by the rules, and where the refusal has not been duly reasoned in accordance with those rules. According to EU law, any court of a member state may request the Court of Justice to give a ruling on a question relating to the interpretation of the EU law. Where a question of interpretation of EU law is raised in a case pending before a court against whose decisions there is no judicial remedy under national law, that is often the superior courts, these courts are required to bring the matter before the Court of Justice, except in certain cases defined by the Court of Justice of the European Union according to the so-called Silfit criteria. It follows from the above that even though the compatibility with EU rules is not within the competence of the European Court of Human Rights, what the European Court of Human Rights can do and does is to examine whether the domestic courts gave a reasoned decision in the light of the requirements of EU law for the refusal to refer a case for a preliminary reference. Now, in the context of several specific fair trial guarantees under Article 6 of the Convention, the European Court of Human Rights has developed certain requirements to be observed. On the one hand, These requirements reflect what the content of the particular right is. On the other hand, in order to demonstrate that these rights were indeed secured to the parties to the proceedings, the courts should, in their decisions, provide certain reasoning. Let me just give one example. Article 6, paragraph 3d of the Convention provides that evidence against an accused must normally be produced in his presence at a public hearing with a view to adversarial argument. The accused must have an adequate and proper opportunity to challenge and question witnesses against him. Under certain conditions, however, it may be acceptable for a criminal court to rely on the statements of absent witnesses. The court's landmark cases in this field are first and foremost Al-Khawaja and Taheri versus the United Kingdom and Shachashvili versus Germany. In Al-Khawaja, the court set out a three-step test to be applied regarding absent witnesses. I will not go into detail as to the test developed in these cases, but I just note that the first element of the Al-Khawaja test is whether there was a good reason for non-attendance of an absent witness. Of course, there is no formal requirement for a domestic court to state those reasons explicitly in a judgment. These reasons may be self-evident or implicit, I mean, for example, if the absent witness is dead. But in practice, in particular cases where the reasons are not so evident, it might prove very useful for the national court to include the pertinent reasoning in its judgment. The nature of the reasoning in domestic judgment has important role in cases where the proportionality of an interference with a person's rights is dealt with. Just again to give one example, in cases where the right to freedom of expression is being balanced against the right to respect for private life, certain criteria relevant for the balancing exercise have been laid down in the court's case law. These criteria include such elements as whether the publication contributed to a debate of general interest, how well the person concerned is known, prior conduct of the person, content, form, and consequences of the publication, and possibly some other elements depending on the particular circumstances of the case. Again, this is not as such a list of elements that necessarily needs to be in the domestic court's judgment. However, where the balancing exercise has been undertaken by the national authorities in conformity with these criteria laid down in the court's case law, the court would require strong reasons to substitute its view for that of the domestic courts. On the other hand, where the reasoning of the domestic courts is insufficient and the interests in issue have not been weighed in the balance, it may lead the European Court of Human Rights to find a breach of the pertinent provision of the Convention or to carry out its own assessment of the merits. In any event, the court has emphasized that the domestic courts should, as a matter of general practice, engage in the balancing of interests and articulate reasons for their decision following this balancing exercise. To conclude, the text of the Convention does not contain a separate right to a reasoned judicial decision. However, in practice, this requirement has been deemed to form a part of the fair trial guarantee under Article 6. Moreover, we find certain specific requirements of specific reasoning in the context of more detailed Article 6 guarantees, as well as in the court's case law concerning various other provisions of the Convention. Indeed, one can say that the requirement of reasoning of judicial decisions is an overarching principle that extends to the entirety of the Convention. I thank you for your attention.
Par to, kā
About how the uniformity of the case law is ensured in Estonia, we will hear from the Chief Justice of the Supreme Court of Estonia, Villu.
Colleagues, thank you very much for the kind invitation to this conference. We in Estonia always wondering how many international conferences are going on in our sovereign neighbors in Latvia and Lithuania, and we are so much behind you. But my congratulations to the Latvian Supreme Court, to the 35th anniversary, and congratulations to all of us for the 75th anniversary of the Convention of Human Rights. My topic today is ensuring uniformity and coherence in the case law. This is Estonian approach for stability, and then the uniformity of case law is very important part of the fair trial principle. And it's not always so easy to achieve it. As I have worked now in the Supreme Court over 20 years, I've seen so many troubles with it. But what is our view here? I think the first and major tool for the achieving of the uniformity of the case law is the three-level court system, of course. And in case of Estonia, we have quite generous application right for the people who are complaining when they are not satisfied with the decisions of the low instance courts. And central importance has, of course, the Supreme Court. But how to ensure uniformity and coherence in the case law of the Supreme Court? Then we have the several different measures, of course. What is important, of course, is the word voting. I have seen in Estonia, at least in case of my colleagues, that judges don't change their point of views very easily. And it's not easy to convince someone to change their point of view. And mostly in difficult cases, there is voting, there is only solution to get out of the situation. In Estonia, we are a small country. We are a small court, and it's a little bit easier as in larger countries, of course, as we are in Supreme Court all united. We have only one highest court and 19 justices for working in civil chamber, criminal chamber, and administrative law chamber. And the Supreme Court also includes the Constitutional Review Chamber, which is composed of justices rotating from other chambers. In case all the highest jurisdictions are assembled into one court, this is easier, of course, to have our case law unified. And in our court, basically one judge cannot decide anything. At least 3 members of the panel are deciding all most important, not most, but all cases, we can see. And if the justices of the panel have fundamentally dissenting opinions in the application of law, it proves necessary to amend the position previously expressed by the chamber. The matter is referred to the full panel of the chamber. This comes time to time, and we can see now in Estonia at least the compositions of the chambers are changed in last years. And so the views to the law are changed in many ways. That means the new composition has other views, and then the many, let's say, old decisions are now overviewed, and then this is some uncertainty in the judicial community, let's say, sometimes. But I hope that now it comes to the little bit peaceful time. It's coming that the new judges are finding their own way. But the most important unifying tool, of course, in Estonia is the plenary session of the Supreme Court for all 19 judges. And the plenary session is considered necessary to, when it's necessary to adopt a different position in the application of law compared to a recent plenary session decision, or for the uniform application of the law, or when the different chambers have the different views to the law. And of course, when this are constitutionality question, of course. We have, I think, so generally 1 to 3 general panels for the unifying the case law in a year, something like that. We have also the special panel possibility when there are different opinions between the chambers. In most cases there are differences between administrative law chambers and civil chambers. Then we have the special panel. In last years, when we say some example, we have several cases for the prisoners' medical treatment. It's a civil case or it's an administrative case. And even we have one plenary session for the case. It was the most important thing for the last 5 years, let's say, for the special panels. But sometimes we even have the special panel between all 3 permanent chambers. Last year we had one, and the question was the legal costs of the attorney, how they should be handled in different proceedings. All chambers had different views on it. Then we had this special panel. There are the possibility, one very used possibility is to have one judge from another chamber in your compositions. It's the right of the President of the Supreme Court on the application of the chamber to take one judge, let's say, from criminal chamber to civil chamber or administrative chamber to the civil chamber. And we use it quite oftenly in the cases there are complex and they have ties to many different fields of laws. And I must say it works quite well. And then when it comes out, there are so very big differences. Then from these compositions, it can come to the special panel or even in plenary session the case. But in most cases, it works without it. Yeah. And there is quite often we use the informal way that one chamber is asking questions from another chamber. We are asking for sending, let's say the civil chamber has the question to administrative chamber, then what do you think when we will interpret the law in such a way? What is maybe not the same, this way that you are thinking? And then say, okay, that's okay, let's do it. Or no, we don't agree that let's go to the special panel, or let's go to the plenary session. It's quite, it's not very common, but it comes time to time. And in some chambers, we have the practice to unify the case law inside within the chamber. Then there is possible that the different compositions of the chambers, we don't have the fixed compositions, but still it comes time to time that different compositions have the similar cases at the same time. and they have different views how to solve it. And therefore, in weekly, every week the chambers are discussing the most important cases inside the chamber, what they are. Then everyone knows what is going on here, and then maybe to avoid the different decisions. And it works, I think, too quite well. One example maybe from the last year, yeah, I think so, as our Constitutional Review Chamber had a case when it was discussable that one punishment was too harsh. It was the previous thing that is too much, it is too high. What's the minimum punishment? And it was the constitutional case, and basically Constitutional Chamber was already done almost the decision in the case, but then just for the case asked for the criminal chamber what you are thinking about it. And it's no, we not agree with it. That then the case came to a plenary session, and the decisions was in opposite way. That's as we thought. But I think it's very important that the decisions of the Supreme Court shows the real majority what they are thinking. So this is the unifying of the case law inside the Supreme Court. The role of the Supreme Court is of course to unify the case law of the low instance courts, and we have in our Code of Criminal Procedure the regulation, which is quite unique, that in the matters of the criminal procedure law are not regulated in the law. The Supreme Court decisions had a precedential effect or value. It's written so in the law, but in factually, I must say there is no big differences compared to other chambers or other questions. Then basically, and in most cases, the Supreme Court's views are followed, and maybe they are discussed, but they're followed from the judicial community without being formally precedents. And it works in informal way mostly. And of course, it's important way, it's the grant of leave system, that what kind of cases we will taking to the decisions. And in our Supreme Court, this percentage is 12 to 13 in last years. Then we search out the cases that need more unifying. Maybe in last years, it's changed the causes, why we are taking the cases. In many cases coming to Supreme Court, you can see some, let's say, something is wrong. This is in most cases, I must say. That's, even when it's not in substantive law, then in procedure, something bad has happened, mostly. But we cannot take every case, and we must trust the low instance courts. Therefore, we had now more going in this way, that we have to unify the case law, and we cannot repair every problem that was in proceedings in low instance courts. I think quite important are the Supreme Court decisions, even in point of obiter dictum, that we explain something that is not exact the point maybe of the case, but very important. We see the problem in the practice, and we try to solve it. Our judgments are annotated, and we are in LinkedIn. We are making them much of press releases. There are commentaries. I think it's very valuable work when someone writes the commentaries to the law, then it goes through the case law, and then there is the best way to find out where is something contradictory, and then sometimes it is, and what is needed to unify. And fruitful, I must say, are the judicial training, what includes in Estonia many round tables within the judges with low instance courts judges. It's now since 20 years we have this practice. It's very valuable. Then the law instance judges can give you very important input. What is the real problems? What need to unify? They can argue with Supreme Court judges when they are not happy with Supreme Court decisions. And it's still a small country. Everyone knows everything, and everyone knows everyone. And then we have it's quite in friendly way. I think it's very important for the Supreme Court to know what problems there really are. Every year the Supreme Court presidents have the overview to the Parliament about the biggest problems of the case law, what need to unify, what lead maybe the changes in the law. Are we following the timetable? Yeah, almost. And maybe for the as last tool, I must say is even the dissenting opinions for the judgments. They are very important to my mind for the judges, but even for the judicial community. Then in many ways I have seen that today this dissenting opinion is for the opinion of minority, but tomorrow it can be the opinion of majority. Therefore, I find that the system is good, and I hope at least in our small country, all the tools are bring this case law in more and more uniformity, and we, of course, want to follow the principle of fair trial. Thank you very much for the listening.
Now we are going to address why and how the right to fair trial in interaction with the principle of effectiveness, or whether and how to respond to arguments that do not need to be answered, will be addressed by Zindra Hamriks, the Center of the Department of Administrative Cases, Supreme Court of Latvia. Good afternoon, dear colleagues. I would like to start by underlining that I'm absolutely honored to stand in front of such an esteemed audience. I'm also very happy to share with you my opinion regarding the justification of court judgments and the interaction with the parties to the case, or how courts respond to the requests for further explanation from the parties to the case. I would like to also start by explaining that I have integrated in my remarks the cases or the case law of the European Court of Human Rights, Supreme Court, and the Senate, but to save time, I will not quote them directly. Instead, I will follow the slides in my presentation where I will have those references to specific cases and case law. Parties to the case always present the arguments that, to me as a judge, are the essential to the case. First, they are instrumental because court needs to resolve the dispute, and the dispute is brought by parties in front of the court. And usually the parties, when they are talking about the rights or the facts, usually, in fact, reveal the very essence of the disputes, and therefore the judge needs to set the limits to this case and shape the case and the proceeding. And to a large extent, the judge decides how to address the particular issue and how to adjudicate the case. Whereas any objections with regard to lower instance court decisions give the judge an opportunity, in the Supreme Court, an opportunity to take a distanced look at the specific details of the case. And I've noticed that judges often have this internal dialogue and actually challenge everything and anything internally and trying to balance the pros and cons of each of the decisions or arguments in order to conduct this balancing exercise. Nevertheless, the opinion of the parties may change the perspective of the judge on a particular case, a perspective that was probably hidden to the judge initially or was overlooked by the judge initially. So therefore, any arguments presented by the parties, if they are well considered, contribute not only to the fair and comprehensive resolution of the dispute or the specific case, but also contribute to the development of laws in general. But that's not all. As confirmed by the Minister for Justice in her remarks, I also believe that the case law with regard to prison conditions has been a strong driver or impetus for the government to introduce new modern prisons, or build rather new modern prisons. One of such prisons is in Liepāja. It's now completed and will be opened, if I'm not mistaken, in 2026. I have to, however, mention here that I haven't taken the picture myself, but because of the copyright that I haven't actually put the disclaimer in for, I took this from the LSM webpage, just to be on the safe side. Of course, analysis of the arguments of the parties in the judgment is also linked to the fundamental rights and freedoms of the parties that are referred to in the first part of the convention and the Article 92 of the Latvian Constitution, which also talks about rights to fair trial, which also includes the right to be heard. It has been underlined by the European Court of Human Rights and also the Constitutional Court in Latvia and the Senate in all three panels and in their case law. But as regards to the administrative proceedings, the law determines how those judgments should be argumented. It's the Article 251.1. So the right to be heard, or in other words, the court must evaluate all of the arguments presented by the parties and reflect them in the judgment in order to show the party that he or she has been heard is a fundamental right that is supported by the Convention and the Constitution and has been recognized and integrated in the legal practice here in Latvia, which makes us ask the question, what happens if the court neglects the arguments of a party? Isn't that a violation of the party's right to fair trial? Well, to answer this question, well, luckily enough, we have a clear answer that has been provided by the European Court of Human Rights in several cases. So it has recognized that the 6.1 paragraph of the Convention does not mean that national court must respond to each and every argument presented by the party. And also in reference to the human rights case law, this has also been supported by the Supreme Court and the Constitutional Court in its case law. As the European Court of Human Rights and National Court case law shows, the distinction between arguments that need to be addressed and arguments that don't need to be addressed, although is not clear, is quite well understood. You need to respond or address the arguments that are essential from the legal and factual point of view that will have an impact on the outcomes of the case, and arguments that have been used as core arguments by a party. And the extent to which you address these arguments or these concerns depends on the circumstances. In other words, the court must see whether its argumentation significantly balances all the important facts, and there will be no need to address the arguments that have been discarded by the court as having low impact on the outcomes, and such a decision of the lower instance court may be the basis for the higher instance court or the cassation court as the reason to dismiss the appeal. But if argumentation provided by the lower instance courts is insufficient, and if the proceeding and the circumstances have led to a point where these arguments have changed or have been interpreted differently, and the parties have have been forced, for example, because of the judgment of the lower instance court, have been forced to present new arguments, then the higher instance court needs to address those arguments. So, to sum up, if not all the arguments are being addressed, this does not constitute the violation of the right to fair trial. If all the instrumental arguments have been properly addressed by the court, including all the circumstances presented by the parties, if they have been sufficiently justified and analyzed in the judgment. And this very well fits into the efficiency principle that has dual impact. On one hand, it ensures the implementation of the rights that are provided in Article 6.1 of the Convention. On the other hand, such approach ensures that the desired outcome in the proceeding is achieved with minimum resources, at minimum time and minimum effort. In other words, it gives a good balance between individual rights of a person to fair trial and public interests with regard to the same rights that are would be impeded if the court would be overburdened with arguments that have very little influence on the actual outcomes of the case. At the same time, undoubtedly, in order to clarify whether the arguments are important or not important to the case, or are irrelevant to the case, or are incomplete and should therefore be dismissed by the judge nevertheless needs to conduct the initial analysis of these arguments or justification, and the party, when presenting the justification, will always think that it is fully justified, or these arguments are important for the outcome of the case, or will show that lower instance court has violated substantial or procedural rights and thus influence the outcome of the case. As has already been mentioned, the right to a fair trial means the same as the right to be heard. In other words, the court must show the party that he or she has been heard, and the only way to create such a certainty is the justification of the judgment. So in its judgment, it must explicitly indicate why certain arguments of a party have been dismissed or found irrelevant. So this raises questions about the efficiency of the court and balancing of the individuals' and society's rights to fair trials. If the court needs to justify anyhow in its judgment why certain arguments have been dismissed, why shouldn't it, fully analyze those arguments? And the answer, or the balance, it can be found in the way how courts dismiss certain arguments. If we look at the bench practices, we can see different approaches to how explicitly it justifies why argument has been dismissed. For example, when appeal is turned down, the collegiate senators need to justify such a refusal because there have been major defects in the appeal, and they can do so in one sentence or phrase, give a general description without the context, and if it doesn't have a clear logical link to the judgment. And party can rightly underline that without the argumentation, without specific details as to what was wrong with the appeal, the court should not dismiss the appeal, which you can actually agree to. But then there's the court efficiency that we also need to consider. The arguments, their inadmissibility, if it is defected, should be accepted if, this phrase or the explanation, if self-evident and fully describes the deficiencies in the appeal and gives full understanding to the parties as to why those arguments have been dismissed, or group of arguments have been dismissed. At the same time, quite often in judgments, we need to explain what were the inconsistencies or defects in the appeal. For example, Senate has, or the panel, the Senate has decided that the evidence has been isolated from the overall evidence, explaining why those arguments or facts have been excluded.
On the basis of my own and my colleagues' experience, I can say that these different approaches how extensively or briefly these explanations are provided, why reasoning has not been accepted. This can depend upon the complexity of the case, and also on the basis of inadmissibility of an argument. The argument has a defect or shortcoming, it's illogical, it's not true, it's selective, and so on. The argument is obviously unfounded, the argument does not have any impact upon the outcome of the case. Argument is dismissed because one ground already allows making the decision, so there's no need to consider other grounds. Of course, the breadth of this reasoning depends upon the instance of the court and the competence of this instance. A court which has the competence to deal with the issues of facts should provide more extensive reasoning for its conclusions, but a court which is dealing only with the matters of law perhaps can provide more general answers. Also, this could depend upon the parties in the case. For example, if the party in the case is not a professional lawyer and is representing himself or herself, then we have explained to these parties how this problem manifested itself. Although all these grounds objectively require different reasoning of the court, why it is not taking into account arguments. However, thinking about the effectiveness of proceedings, we should aim for such wording of the court's reasoning that would in general describe the shortcoming of the argument, and also providing very brief explanation regarding grounds for dismissal. And in conclusion, I would wish to all of us the ability to maintain balance in this age, which is oversaturated with information, where the deficit of time is directly proportional to the increase of the amount of information. And I hope that being aware of the need and significance of the balance between the interests of an individual and society, I hope that we'll be able to find the golden mean in each and every case and somehow balance on this blade of whatever the risks this entails. Good luck to us. I would like to thank all the speakers for their positions and approaches, and I believe they all share the finding that the reasoning of a court decision is very important for the rule of law, openness, and also for protecting human rights. But now I have an announcement regarding another topic. We are going to have a 15 minutes break. And we kindly ask you all to come back on time. Thank you. 15 minutes break.
Cienījamie kolēģi,
Dear colleagues, please take your seats. Choose the best seats. Lawyers and judges are usually people are always on time, so let's really confirm this stereotype. Dear judges, participants, we are all celebrating today. We are celebrating a fair trial. We are celebrating fair rule of law in Latvia. And during this second panel, we will speak about transparency in the administration of justice. This is, the court has been open it has held the sessions on the main square of the town, Market Square. But now we have to speak about the dialogue with society, the quality of court rulings, access to court rulings, timely access. And we are administering justice not in the name of God, but in the name of the Republic of Latvia or another state on behalf of the nation. And here we see two dimensions. On the one hand, we have the private interest Each person is interested to get justice in his or her case and to understand why the justice has been administered in a certain way and the reasoning. We have fundamental rights, human rights, on the one hand. On the other hand, we have the public interest, because a state governed by the rule of law and all inhabitants are interested in a fair trial. And this creates trust in law and to a certain extent impacts loyalty to the state. We have gathered here from the countries from around the Baltic Sea. We are all close neighbors. And so we'll talk about transparency in the administration of justice. Each of the speakers is taking a different perspective to this issue. I looked at the biographies of our judges. We have a civil law judge, criminal law judge, and a human rights judge currently working in administrative court. So we really cover the entire field. And I'm very happy and honored to give floor now to our colleague from Lithuania, Danguolė Bublienė. The floor is yours.
So, thank you, Sanita. So, esteemed colleagues, first of all, I would like to thank you to the Supreme Court of Latvia and especially to my colleague Aigars for inviting me to this wonderful conference, and also taking this opportunity. I would like to congratulate all of you on 30th anniversary of the restored cassation instance. And now I would go directly to my speech. Almost every speech and article concerning the openness of courts starts with the same quote: "Publicity is the very soul of justice." These words penned over 200 years ago by the English philosopher and lawyer Jeremy Bentham are strikingly timeless. The openness forms part of the larger task of the modern judiciary to keep the public informed as to how justice was achieved in their name. Thus, the functional openness of courts, focused on practical commitment to communicate with the public, is regarded as highly as the traditional doctrinal openness encompassing rules on transparency and publicity of hearings. Even fourth, most of the courtrooms are open to most of the people. Most of the time, people are not keen to sit in public trials. They are usually informed about important cases and the materials related to them through reporting done by media. This particularly applies to the Supreme Court of Lithuania, where proceedings are almost always, especially in civil cases, carried out in written form. In other words, there is no traditional public hearing to attend. That is why the media and its timely access not only to courtrooms, but also to subsequent court records are of crucial importance to journalists, society, as well as the judiciary. However, the relationship between media and courts has always been ambiguous. Although the principle of open justice is in the text of Article 6 of the European Convention on Human Rights, it comes with an immediate restriction that the press and public may be excluded from all of or part of the trial. Moreover, the general duty of journalists to play the democratic role of public watchdog, which extends to the reporting on court's proceedings, has to be carefully balanced against the involved parties' rights to privacy and protection of their private lives under Article 8 of the Convention. Even more practical nuances have to be considered now, as the media landscape has expanded to include bloggers, YouTubers, and other new forms of journalism. When in Lithuania have relatively recently started paying much more attention to this matter. The Supreme Court of Lithuania has dramatically increased the number of press releases on adjudicated cases, which proved to be eye-opening. Initiative on our part to have press releases for roughly 1/3 or more of our adjudicated cases has provoked a heightened attention to our cases from the media. And suddenly, we found ourselves being asked for much more than just short pre-approved messages in the form of a press release. Journalists now inquire why we do not give them unredacted or non-anonymized versions of final decisions. Why are we not agreeing to email some excerpts from judicial files? Can we not reveal the content of the cassation complaint, or at least the crucial arguments, before the final decision is adopted? Why cannot we tell them information of personal nature about litigants over the phone? It cannot be again the fault of GDPR, they plead. All of these and many other similar questions arise in the courts because of the unavoidable daily balancing of the freedom of expression of journalists, privacy of the parties, and lastly, the open justice principle. The term open justice, which we are only getting familiarized with in continental Europe, can be generally understood as comprising mainly public hearings, accessing information about the case, as well as accessing court decision and case materials. Some of the restrictions of the open justice principle are historically well established and apply in virtually every European country. For example, in order to maintain the case's integrity, the sub judice doctrine forbids the publication of material on ongoing cases, as it would endanger due process. Likewise, according to our national procedural laws, the court has to allow persons, including journalists, upon their request, to broadcast, film, record, or take pictures during the public hearing. Moreover, it is widely accepted that certain circumstances require courts to declare parts of case material not public or to hear cases in closed hearings. Such circumstances might relate not only to parties' private or family life, information about a person's health, but also secrets of the state, civil service, office, or commerce. The media itself accepts such a framework and in principle does not question its enforcement. Also, the necessity for such occasional derogations from general openness, which directly impede the open justice principle, is confirmed in the case law of the European Court of Human Rights. Furthermore, the once heated discussions on the possibility of releasing full court judgments to ensure restricted freedom of information are fading from the public discourse. Instead, by now many courts, be it national or European, provide their case law to the public in somewhat obscure form due to anonymization or pseudonymization of final decisions necessary to safeguard the parties' interests. Without delving further into this issue of anonymization, as it is not the direction I would like to pursue during my presentation, I will only mention that, like in many other countries, the final court judgments in Lithuania are published in their anonymized version. We replace full names of the parties with their initials and redact some of other sensitive information, such as relating to the parties' health, nationality, or workplace. This started in 2005, long before the adoption of the GDPR. However, we have just recently revisited this practice and reframed our aim of anonymization as informing the public about the interpretation and application of law in our courts. But clarifying the aim of publishing anonymized decisions has not solved the issue of providing information to the media. We still do not have the answer to whether or not the court can provide members of the media with the original non-anonymized version of the judgment, with a caveat of journalists' own responsibility to later use it lawfully and follow the requirements relating to data protection and respect to a private life. To address this issue, the Judicial Council established a working group that includes judges, court staff, government, and media representatives. The goal of this group is to define issues emerging when reporters seek to get information from the courts and propose possible regulatory solutions that would make the whole exchange between courts and the media more effective. This, of course, will prove to be challenging, as the existing system was created without the disruptive impact of the General Data Protection Regulation in mind. The GDPR has significantly altered our overall approach to personal data, its sharing with third parties, and the broader question of protection of litigants' privacy. We have moved on from the initial reading of the regulations text as possibly not applicable to courts acting in their judicial capacity. After several rulings of the Court of Justice of the European Union, it is clear that the Court not only interprets the concept of court acting in their judicial capacity broadly, thereby exempting their data processing operations from the supervisory authority oversight, it also submits the judicial activity of courts to the obligation arising out of the GDPR. Thus, we no longer discuss if, but try to grasp how exactly the GDPR requirements bleed into our day-to-day work. At least at first blush, the GDPR superimposes an all-encompassing data protection framework on the judicial function, which must be complied with. In theory, all the general mechanisms of the GDPR apply to the judiciary, the fundamental principles, the 6 bases of the lawfulness of data processing, and the rights of the users. Compliance with the requirements of the GDPR ensures the protection of the right to private and family life and the protection of personal data. However, it appears that the mere presence of personal data, which forms a part of the broader right to protection of the right to private life, does not in itself justify declaring a case partially or entirely not public, or holding a closed hearing. A different interpretation would imply that, due to the amount of personal data in each case, all hearings should be held behind closed doors, thus undermining the open justice principle altogether. Moreover, member states are allowed to restrict the scope of the rights and obligations provided for in the GDPR in order to protect judicial independence and judicial proceedings. This supposes, as the Advocate General Michal Bobek suggested in his opinion, that any national legal basis established under Article 6 of the GDPR needs to address a general and ongoing practice of disclosing documents to the press. Accordingly, where such a general legal basis in national law exists, it is difficult to justify the necessity to individually assess every single processing operation that emerges whenever the media asks for information. But setting up such a system is particularly challenging due to currently still unclear breadth and depth of the GDPR applicability to judicial activities. For example, in Lithuania, according to civil procedure laws, all cases materials, except for cases that were examined in closed hearings, shall be public and available for persons absent from the proceedings. The persons have the right to make copies and extracts of the case materials, but only after the judgment comes into force. Such a rule clearly is a reflection of the before-mentioned sub judice doctrine and is neither primary concerned with the protection of parties' privacy nor considers their interest. Otherwise, it would be difficult to explain why such considerations would expire as soon as the case is finished and the judgment becomes final. Furthermore, such a rule means that a person, including rapporteurs, can access all case material which was not officially declared to be non-public, including any personal data it contains. Following the opinion expressed by the Advocate General, it might appear that such a national rule, which is as old as our Code of Civil Procedure, indeed serves as a general legal basis to share the documents with the media and therefore is in line with the requirements of European data protection standards. However, the Court of Justice in its ruling ECTHR and authoritative personsgegevens has steered clear of the question regarding the substantive assessment of sharing the court documents with the media under Article 6 of the GDPR, thus leaving us without a clear answer on whether and how the individual assessment should be carried out in order to comply with data protection requirements each time the media asks for something. This question is particularly important because of the Court of Justice line of reasoning in its other ruling. For example, the arguments provided in the Per Nikander case concerning disclosure of evidence in civil proceedings suggest the importance of taking into account, among other things, the principle of data minimization, which gives expression to the principle of proportionality. If fully applied across the wide spectrum of judicial activities, this principle would raise the question of whether the case materials provided to the media should also always undergo a balancing test, with data contained in case files as a result obscured or hidden in some fashion, for example, redacted, painted over. Additionally, the results of the outcomes of the proportionality assessment and the GDPR system may not always align with the assessment considering restriction on the media's rights to freedom of expression under Convention. All of this would seriously challenge the practical application of such requirements in court handling hundreds, if not thousands, of cases and could undermine the effective administration of justice. The solution that our colleagues from Sweden have relatively recently found for this issue of providing materials requested by the media and assessing such requests through the lens of the GDPR requirements was in the Panoptis Sweden case. Rather than conducting an individual assessment of each requested document from a large volume of case materials, the balancing of the data subjects' rights with those of the news agency was achieved by imposing restriction on the subsequent use of the provided materials. This approach, however, raises the question of whether such limitations on material use are acceptable under the GDPR. Finally, I would like to conclude with a continuation of the same quote of Jeremy Bentham that I started my presentation with. It is through publicity alone that justice becomes the mother of security. By publicity, the temple of justice is converted into a school of the first order, where the most important branches of morality are enforced. We are currently standing at the crossroads. The yet unclear breadth and depth of the GDPR application to judicial activities can affect the relationship between courts and the media, from formally ambiguous to outright confrontational, where journalists demand information, yet the judiciary refuses to disclose it due to data protection concerns. Consequently, that would mean fundamental alteration of the understanding of the open justice principle and a serious challenge to the effective administration of justice, which seemingly should be the primary concern of the courts. Thank you for listening to me.
Jā, liels paldies Lietuvas augstākās tiesas priekšsēdētājai.
I would like to thank once again the President of the Lithuanian Supreme Court and turn the floor over to our colleague from Sweden, the former judge of the European Court of Human Rights and the current President of the Supreme Administrative Court of Sweden, Helena Hedeblom. Please, the floor is yours.
Thank you. And thank you to our Latvian colleagues who have invited us to this seminar today. Special thanks to President STRUPIŠS, of course. It's a pleasure to be here. Now, I would like to echo much of what President Bublieni has already said, and she has also mentioned a Swedish case, and I will come back to that. But it really, the principle of openness of courts and court hearings and court material cannot be underlined enough. And the right to fair trial, according to Article 6 of the European Convention, of course, presumes that in criminal proceedings and that parties to civil proceedings are afforded a right to public hearings. And this is a means to protect them. And we must not forget that, protect them against administration of justice in secret and without public scrutiny. This is at the core. However, we know that such obligations to hold hearings is not absolute. There are several examples from the case law of the European Court allowing exemptions from the right to oral hearing. And there are, of course, many court proceedings that have no bearing on criminal responsibility or civil rights and which are mainly or exclusively administrated through written proceedings. The question is to what extent parties' written submissions and documents produced by the court itself and by possible interveners become accessible to the public. And public accessibility to judgments serves several aims. Access provides the public with the possibility to understand and to scrutinize the judiciary, the bearer of such important powers, and it contributes to upholding the legitimacy of the judiciary. It is also indispensable, of course, for the legal professions of all kinds to be able to prepare and carry out their work. If we start by judgments, Article 6 states that judgments shall be pronounced publicly, and although it does not explicitly provide for subsequent publicity or publication of written judgments, the starting point is that judgments and other final rulings are made available on request, and sometimes they are also published by the courts. And the parties, of course, must be expected to have the judgment delivered directly to them. A judgment may, of course, contain information which is sensitive for various reasons, and secrecy exemptions may warrant the redaction of such information in the public version of a judgment, or alternatively, the anonymization of parties and others involved in the proceedings. The European Court of Human Rights have found violation of Article 8 in circumstances such as the right to protect the identity of, for instance, an HIV-infected party. And this was made public through a judgment, and this was criticized and found a violation under Article 8. So the balance against Article 8, which President Bugliani also has underlined, is of course important. And here is also where the GDPR comes into play. Now, if we turn to Sweden, the Swedish secrecy legislation is quite complex. But in short, secrecy may apply in the courts either through directly applicable secrecy exemptions, or because secrecy is transferred from another inferior court or authority. The main rule is that secrecy ceases to apply for information which is included in a judgment. And in order for secrecy to prevail, for information that was presented during a public hearing and after a case is closed by a ruling, two conditions have to be met. Firstly, the hearing must have been held in camera. And secondly, the court must explicitly declare in its judgment that the applicable secrecy exemption shall continue to apply. So it's not enough to hold a hearing within closed doors. You also have to, in the judgment, once again, assess whether secrecy shall continue to apply. Otherwise, it becomes public, the information. Furthermore, in special situations, the court may also declare that secrecy apply to information in the judgment if the interest of secrecy significantly outweighs the interest of publicity. And this possibility is used very, very sparingly. Typical examples are addresses to parties who are afforded protection for personal security reasons, and the identity of victims of sexual offenses, but never the identity of suspects in criminal cases. As an example of how we tend to deal with sensitive information in cases of compulsory care of children, which is a very common group of cases in my court, instead of anonymizing the identity of the child or decide on secrecy for parts of the judgment, we try to adapt our descriptions of the child's situation, for instance, the conditions that the child lives in a way that doesn't describe in detail the situation. Instead, we will try and minimize the description to the extent possible to still make our reasoning in the judgment sufficiently understandable. And as we have heard from our previous panel, this is also an important aspect of Article 6. The starting point is that judgments in Sweden are official documents which are accessible to any person upon request, either by reading the judgment on the spot on the premises of the court or by receiving a copy. And if the judgment contains secret information, that information will be redacted. Individual requests to have a copy transmitted by email is also normally granted. And apart from the individual right to request a copy of the judgment under the general rules on access to official documents, the two Swedish Supreme Courts, the General Supreme Court and my court, the Administrative Court of Supreme Administrative Court, we publish all our rulings on our website. But these are always anonymized as regards private individuals. And the same publishing policy applies to judgments of a jurisprudential interest from the general as well as the administrative courts of appeal, the second level court instance. Now, newspaper and other media outlets, as well as companies who sell information, they contact courts on a daily basis, requesting access to all new rulings. And they demand to receive them electronically. And of course, here the GDPR comes into play like a wet blanket. The Swedish General Supreme Court, as President Bublieni just mentioned, has recently decided to set out as a condition for such access for judgments in criminal cases that access is granted on condition that the judgments are not redistributed to the public unless anonymized, invoking Article 10 of the GDPR. So this will make it impossible for the outlets that sell information to paying customers. This is not something that we have imported strictly to my court. First of all, we don't deal with criminal convictions, but so far my court, the Supreme Administrative Court, we are responding to corresponding requests for our judgments via electronic distribution. And then, of course, Article 10 is not relevant for our cases. I should mention that the case decided in the Swedish Supreme Court, in the General Supreme Court, we had 3 judges from my court taking part in that. We have a possibility to exchange judges between the courts in the Supreme jurisdictions. It's something that we have been able to do since 2017, and we use it quite often. In this particular case, 7 judges were sitting in the General Supreme Court, which means that it was a very important case, and 3 of the judges came from my court. And 2 of the judges dissented in this judgment, and those 2 judges came from my court. So you see that we have a sort of internal conflict now in Sweden as regards the stance on these issues. We will see interesting developments, I'm sure. Now we look at the European Court of Human Rights. The convention itself states that the final judgment of the European Court of Human Rights shall be published. And this is, of course, done in the UDOC database, of which you are familiar. So it's published on the court's website. And nowadays, the Strasbourg Court's judgments are often, but not always, anonymized. And according to the rules of court, anonymity may be granted on request or ex officio. However, regardless of the sensitivity of information from a privacy aspect, judgments used to always be published without anonymization in the form acronyms for individual parties. And these older judgments often remain in full with the names published on the website, even if it's very sensitive, for instance, child custody cases, etc. Recently, the EU court has started to anonymize its judgments as well. And we received a preliminary ruling recently where it was explained in the footnote. I'll see if I can find it. It was stated, here we have it. In the case of AA, which is not the abbreviation of the private party's name, because his party is called something else. It's actually a Finnish name. I might be able to reveal, but the case has now been named Palmstråle. So that's a fictitious name. And it's not any of the participants in the case real name. The case is about export of horses. Maybe it was the name of the horse, I don't know. I think this is done automatically by some AI-generated mechanism, but palmstråle means palm tree beam. It's very interesting, and it's a bit IKEA-ish, in my opinion. This is how IKEA sort of names their furniture. I don't know, Anita, are you using the same program? Anyway, so nowadays also the ECJ is anonymizing private parties, which I don't have a problem with at all. But if we turn from judgments to process material, it is of course inherent in the Article 6 right that parties should have right to see the submissions of their opponent. And although this doesn't really follow from Article 6 explicitly that this should apply to the general public, as we have seen, we do differently in different countries. Anyway, Sweden is one example where the general access legislation applies, and the starting point with our courts is that you have a right of access to all process material from the time it is being submitted to the court, or if it's produced by the court itself, you have a right of access. And secrecy exemptions may apply, but not in order to protect the proceedings, but to protect, for instance, privacy, economic interests, etc. But all process material is, as a basic rule, public and accessible to the public upon request. And the same basic principle applies in the European Court of Human Rights. According to Article 6 of the Convention itself, documents deposited with the registrar shall be accessible to the public. And then there are rules of court laying down secrecy exemption to protect public and private interests to a certain extent. But the basic rule is that you have access to the Strasbourg courts, all the interventions during the proceedings, before the ruling is made, there is a basic right of access. This does not apply to the EU court. It's totally the opposite in the EU court. The presumption by the ECJ is that third-party access to the process material undermines the sound administration of justice and the equality of arms principle. And this was obvious in an old Swedish case where the Swedish Journalist Union won a case and their litigation costs were significantly reduced because they published their own intervention and other interventions. So it's a totally the totally reverse principle that applies to the ECJ. So this, I think, is interesting, and I don't know what conclusion to draw from this, but it is quite difficult to understand for me. There are differences in the approaches in various national systems as regards public access to rulings and process materials. We have seen that as well as with the two European courts. And I think, in my opinion, it would not be consistent with the right to publicity of court proceedings inherent in Article 6 to generally exclude a right to public access to such material, albeit that secrecy exemptions may always apply to certain extents. Now, the case law under Article 6 of the European Convention may develop in these respects, but regardless of that, it appears that there is a broad understanding today from the judiciaries in various states that public access to court material is of utmost importance in a democracy based on the principle of rule of law and respect for human rights. Thank you very much.
Thank you so much. And now we are asking our own expert in openness of transparency in administration of justice and public involvement and public backlash to fair trial. Māris Leja, Senator of the Supreme Court of Latvia, Department of Criminal Cases. Dear colleagues, to introduce into the topics that I have chosen for the event of today, I would like to say that I will ask you to look at the transparency of proceedings and perhaps take a bit different look at it. And I will start by asking two questions to you so you can try to answer these for yourselves. It will be a very short introduction into the topic that I'm going to discuss. And so, isn't it so that more and more often it's not the court that administers justice, but the public regarding the guilt or innocence of a person? And isn't it so that sometimes you get the feeling that there are some experts, perhaps in quotation marks, or media usurp the function of administration of justice? These are the two questions that I wanted to start my intervention with. Until now, in connection with criminal proceedings in mass media and also on internet platform, information that has been published on criminal proceedings, we see that most often we see that society, before the conviction, makes the suspect or the accused person guilty. The purpose of my intervention will be to take a different perspective on this matter, namely the situations when publishing of information or biased presentation of information in mass media on the internet is used to create the perception that the accused person is innocent. Well, that's and also to create the perception that law enforcement institutions are acting unlawfully in their daily work.
And this manipulation can be done by media as well as the accused themselves, especially if they are publicly known or popular individuals, and they might create the impression to the public that not only is the accused innocent, but also that the state institutions are failing and are actually breaking the law instead of protecting the law in the case of these individuals. As I analyzed this issue, I was also compelled to include my experience of working as a public prosecutor for almost 25 years. And I was actually part of such proceedings from time to time myself. And, you know, there are a lot of examples. If you would ask Latvian colleagues, they would immediately say Lemberg's case. And since we have foreign colleagues here, I would like to also describe to you what the case is about. Aigars Lembergs is a mayor of Ventspils who over the course of many years used public media in order to promote himself and used it for the political advertising. He regularly published various videos, and court proceedings were accompanied by protests and supporters who came in buses, in droves, with flowers and so on and so forth. So as a result of this public campaign, if you will, quite a lot of people started thinking that this criminal case against him is bogus, is sham and unfair. Why am I concluding this? Well, because I know the municipal election results. His party, Lemberg's party, was the leader in his municipality despite all the criminal proceedings against him, criminal accusations against him. Another example from Germany, which I very much like and analyze, Jörg Kachelmann's case. He was a very popular TV presenter who faced the court in 2005 for rape, and media twisted the case and, launched this war between the accused or the defendant and the court, where both sides actively used media, and Kachelmann even hired a media company that helped him with this, public or media campaign. The funny thing about this, one of the funny ways he used it was that he encouraged people to vote, whether he's innocent or guilty. At the end of the day, he was found not guilty, but still quite many people thought that those accusations were unreasonable, ungrounded, and the case should have never ended up in court. And this impression created problems for a judge, and judge tried to dispel this impression, but I'll talk about it later. And also another case from Italy, Knox case from Italy, and that's an example of foreign media intervention, especially when a foreign citizen is involved. Now let me address some of the problems that I wanted to talk about in my remarks or in my address. On one hand, both media and the accused have the right to express their opinion. Nobody doubts that, of course, but as practice shows, and as the examples that I mentioned shows, they often go over the acceptable limits when it comes to manipulating the public thought and putting the case to a court of public opinion. And they have employed very extensive means of manipulation. And I would like to focus on two aspects here. What are the risks of such manipulation or media campaigns by the accused, and how to mitigate those risks? I'm fully aware that in the time given to me, I will not be able to provide recipes and provide a very thorough analysis of these phenomena. I will rather try to shed a light on this problem as much as possible and show you how important it is to address this problem. Because, first of all, if we are unaware of the gravity of this problem, we will most probably not be reacting to it. At the same time, I would like to also underline that any solutions that are possible to this phenomena, or this case, should work in both directions. Should be effective when the accused are trying to shift the blame or guilt away from them and trying to shift the guilt on the judicial system, and also when they are being they are found not guilty as well. So I'll try to describe the main threats or risk factors. Of course, not all of us can see these risk factors immediately. They are not obvious, and I will try to make them apparent or obvious just to remind you of them. If media think that the journalistic opinion is stronger or better than the courts, it minimizes the influence of courts. One-off case, that's not bad, but if this continues, if this becomes a system, and if any proceeding becomes a battlefield, the society might start thinking that there is no truth, unbiased, impartial truth, and why do we need courts if there is no universal truth or impartial truth? And also, if people will get used to pseudo proceedings, it might undermine the trust to the courts, and people will start thinking that courts are not the right place where to decide whether someone is guilty or not. And secondly, it might create pressure on the parties or participants in the case if testimony or evidence or proceeding in general is widely covered by media prior to the proceeding. Witnesses might wittingly or unwittingly align their testimonies or start doubting their recollections or memories. If there is a victim who is the main witness in the case, if being slandered might even ignore the summons to the court. And we might say that we are judges. This is my third statement. By undermining the courts or undermining the integrity of the courts, we are also undermining the integrity of the judges. And also when you
Lay judge.
And when you have jury and lay judge, that may even create additional doubts about the integrity of the proceeding. And if not only the judge himself or family members are attacked, then that might even further compromise judges' work. And such successful media campaigns, and if they are successful in showing that the accused is not guilty might encourage the others to try to launch similar campaigns in other proceedings or other cases. When it comes to Kahelman's case that I mentioned in my introduction, what I would like to specifically underline is that in that case, it was even concluded that the victim slandering campaign and impact or influence on the court had reached the level where it began undermining the rule of law. So that's as far as negative risks are concerned or threats are concerned. Now let me address the countermeasures and how we could mitigate those risks. Well, we have done very little to actually mitigate those risks. That's my personal opinion. Not only are we not solving the problems that have been already detected, but we haven't been proactive either. We haven't been preparing ourselves for the future, for the AI deepfakes and so on and so forth. The reason is very apparent, at least to me, is that probably we're not fully aware of the gravity and the magnitude of the problem. Our current legal framework not only overlooks it, but it doesn't allow it to efficiently address it. Let me mention an example. According to criminal procedure law, the case files are an investigation secret of the investigation, and can only be revealed with the investigative judge's mandate, and there is a criminal penalty if you disseminate any information without the authorization of the judge or the prosecutor in charge, investigating prosecutor. Unfortunately, this doesn't work in practice. We had 2 criminal proceedings based on the same article, and in one case the person was found guilty and in another one not guilty. My experience as a prosecutor shows that this article cannot be effectively applied because it is very difficult to identify the leak, the source of the leak, because very often a reprimand is being expressed to several individuals. You can only guess who has actually leaked the information about the criminal proceeding. And also our media law says that you cannot publish pre-trial investigation materials, but this restriction doesn't really imply any penalties. Now, let me talk about solutions and how we could solve these problems. Undoubtedly, everything that I said points towards finding ways to ensure the efficiency of all the legal mechanisms and instruments and tools. But for me, it is even more important to ensure that you can implement countermeasures, timely countermeasures that cut such media campaigns at their root and are stopped immediately, because when it comes to legal liability, that can only be applied after the violation has taken place. And now let me indicate some of the solutions on how we can solve that by requiring legal liability as well as other kinds of liability. Now, as regards to the efficiency of the legal liability and applying legal liability, I think we should find instruments that would be easier to apply compared to criminal penalties. Criminal liability, in my opinion, of course, would be very efficient. Nevertheless, this liability should be limited to physical or natural persons, should also include media platforms or digital platforms and media that should be also held accountable. In order to make the evidence gathering easier, we should also make it obligatory to reveal the authors of the articles, because such anonymity significantly hampers either the investigation of the leaks and the identification of the individuals behind them. And judges and prosecutors should also be given additional means to prevent such cases. And this brings me back to the Kahelman case. When the judgment was read in the Kahelman case, a judge criticized heavily mass media and internet platforms during and how they behaved during the proceedings, indicating that facts presented were incomplete and were twisted, and comments blatantly violated both the rights of the accused and the judge to privacy, and also indicated that some of the media even encouraged the public to vote on whether the individual is guilty or not, making it an entertainment ridiculing basically the case, and eventually the judge also commented the evidence in his judgment. The judgment or the ruling not guilty doesn't mean that we think as judges or the court thinks that he's not guilty. However, we couldn't fully prove his guilt and we had to acquit him and release him. We are releasing him on the condition that he might be guilty, but this is something that we'll not be able to prove later on. You can continue as media writing about it, but you should take into account that Mr. Kachelman might not have committed the crime, but you should at the same time remember that the victim has been a subject of a grave crime. Now, as regards to other activities that we could implement apart from the legal liability, how we could prevent such campaigns or attempts. So we should limit the publishing of different materials, or we should provide for the opportunity to request to delete certain information or materials. We should consult the experience of other countries that are further ahead in this regard than we are, and that have already implemented different countermeasures and see whether we could replicate their practices, best practices. To conclude on the other solutions to this problem or other ways how to prevent such media campaigns. In conclusion, I would like to give some food for thought for you. Something to think about apart, in addition to what we are going to eventually choose. In order to adopt decisions regarding the publishing of the media, it is very important to have trust to government institutions, their ability to explain and justify or reason for such restrictions on openness. When we are considering openness restrictions, we must work very, very much with the public awareness. Any precondition for any restrictions of the information openness is the public support, and I will be rather pessimistic that I think that this is very hard to achieve. COVID-19 and the war in Ukraine has shown very clearly how difficult it is to explain to people and persuade people that we need restrictions from the government. That's all from me. Thank you very much.
Paldies visiem paneļa.
I would like to thank all the speakers of the panel. We saw how hard it is to work with transparency in the administration of justice. Sometimes the justice was administered in the town square publicly. Anyone could come and listen. We are flooded by information and norms, and we live in the postmodern society with fantastic dilemmas of values. Also, protection of privacy and personal data becomes stronger, and it is somehow in conflict with this requirement of transparency. And I have the feeling that all courts are juggling with the balls in the matter of transparency and are getting more and more balls. And this is my question that I wanted to raise. During the COVID time, we introduced remote court hearings. The courts kept working. But how is it with respect to any person's right to enter the courtroom if it's an open hearing? Can we have such online court hearings without streaming? Aren't we stepping away from the transparency in the administration of justice? And all these questions and issues related to modern technologies, manipulation with public opinion through interventions from foreign countries. We have more and more questions like that. And it's very good that we meet at a discussion table, but from now on, we will meet at a dining table for lunch, and we come back exactly at 2:30.
Labdien!
Good afternoon. Thank you for coming back right on time. We have reconvened after lunch for the second part of the conference. And we'll have the keynote speech, first of all, followed by the third panel of the conference. I'm very happy to announce our keynote speaker, Inese, Judge of the Court of Justice of the European Union. All of you probably know Inese has been a judge and president of the Latvian Constitutional Court and also judge of the European Court of Human Rights. Usually, well, after lunch, it's a bit difficult to listen, but I am quite convinced that Madam Ziemele her keynote speech will keep us all awake, and it will be a very valuable speech to listen to. Thank you, Anita. Good afternoon. Well, I congratulate you on coming back and coming up to this floor after lunch. And we will have the possibility to spend approximately 20 minutes together. I thought that probably during the first part of the conference, references to all articles will be made. All important case law would have been already quoted. So how to entertain you after lunch? Not speaking seriously, and yet speaking seriously, I decided that I want to tell you about a book, and I want to link this story to the right to a fair trial and independence of courts. The reason why I chose to tell about this book is actually what we heard during the morning part of the conference, and namely that we are celebrating very important anniversaries. 30th anniversary of the Senate, and dear senators, I congratulate you. And we also are celebrating the 75th anniversary of the convention, and I congratulate all of us. But we are marking these anniversaries at a time when the goals of the convention are being threatened and jeopardized from outside, but also internally. And this my speech will be about this. I would like to recall the statements made in the preamble to the convention, and I quote, reaffirming their profound belief in those fundamental freedoms which are the foundation of justice and peace in the world and are best maintained by an effective political democracy on the one hand, and on the other hand, by a common understanding and observance of the human rights upon which they depend. So the member states agree on a catalogue of human rights in the convention, which is a minimum catalogue of rights and effective protection of these, especially in independent and objective court. Pursuant to Article 6 of the Convention, the content of which has been taken over and included in Article 47 of your Charter of Fundamental Rights of the EU. So Europe, after the end of the Second World War, represents such understanding of the world where justice and peace are fundamental values, and these can be attained by ensuring protection for human rights and a truly democratic political regime. Thus, I would like to turn to the question of the court's role in the protection of truly democratic political regime, because currently we are in defense positions. And I will do this in an untypical way, because in order to understand the importance, the huge importance of this question in this time that we are living in now, we should understand what's currently going on. And I would like to go a bit deeper. The good news is that in the Western democratic world, we have outstanding scholars and experts of politics, rights, and other areas, and we should read it, not limiting ourselves to titles on the news headlines, or postings on social media. And I believe that one of the most exhaustive description of the threat to democracy, also pointing to historical sources, have been provided by Anita in her book that was published in 2024, Autocracy Incorporated, The Dictators Who Want to Run the World. This is not her first book, but it was awarded the prestigious Pulitzer Prize that was established in 1917. That was prize in journalism, literature, and art. And this prize is awarded every year by Columbia University, one of the influential universities in the United States. So I would like to introduce to you the findings that she has included in her book, Autocracy Incorporated. The first valuable thing in this book is a definition and description of autocracy, followed by examples on all continents: Iran, Russia, China, Venezuela. The author underscores that a person who lives in democracy perceives autocracy in the following way: the bad dictator on the top of the power controls army and policy and threatens his people with revenging for disobedience. And he has evil collaborators and some very courageous dissidents. Most probably, this is how we understand the events in Russia. However, in our age, in the 21st century, this picture is very far from reality. Nowadays, autocracies are run not by one bad guy, but by sophisticated networks relying on kleptocratic financial structures, a complex of security services, military, paramilitary, and police, and technological experts who provide surveillance, propaganda, and disinformation. The members of these networks are connected not only to one another within a given autocracy, but also to networks in other autocratic countries. And sometimes in democracies too, corrupt state-controlled companies in one dictatorship do business with corrupt state-controlled companies in another. The propagandists share resources. The troll farms promote dictators' propaganda and spread of this propaganda. And this should not be perceived as activities organized in one secret room. Each autocracy has its own history, its interests and aims. In difference to military blocs during the Cold War, current autocracies do not form one military bloc. It is a agglomeration of companies linked not by ideology, but by the brutally pragmatic approach to their wealth and power. So this is Autocracy Incorporated. They are united by determination to deprive citizens of any real impact or public voice, to destroy any form of transparency and form of responsibility, and repress anyone domestically and outside who challenge their power. They all share the brutally pragmatic approach to wealth, in difference to Nazi and communist leaders who were not showing off their ways. These guys have unimaginable wealth. Their their bonds with one another and with their friends in the democratic world are cemented not through ideals, but through deals deciding to take the edge of sanctions, to exchange surveillance technology, to help one another get richer. Applebaum also notes that in the 21st century, we have successors to Nazi and communist ideologies, irrespective of the forms and words in which these ideologies have been transformed into. And I call and the enemy of all of them is the democratic world. Namely, the West, NATO's European Union, democratic opposition, and liberal ideas, which have inspired the democratic world. These ideas cover the law and legal acts as a notion of neutral power which is not subject to the changes of political winds. The fact that courts and judges are independent, that diversity of opinion and political opposition is legitimate, that we have the freedom of speech and independent journalists who criticize the government but are loyal to the state. Autocrats hate these principles because independent judges can make them liable and usually ensure that those who are in power are responsible for their actions. Human rights and independent judicial power, other independent institutions empower citizens, their participation, which periodically lead to the change in government. And I was very impressed by one of the theses of Applebaum, that autocrats are afraid of transparency, responsibility, the rule of law, and democratic conversations, because these, in fact, address the majority of people. That is why, in its propaganda, autocracy does everything to slander these ideas. As we know, the central idea of the EU is the internal market and united space of freedom, rule of law, and security. And this united space of freedom, rule of law, and security was the central role played by mutual trust and loyalty also among courts, based on uniform understanding of EU legal provisions and application, abiding by the European Convention on Human Rights and the EU Charter of Fundamental Rights, is the response of European democracy that autocrats dislike. This space provides to the citizens of EU and their families more rights than it would be possible within the framework of one democracy, and therefore it empowers civic support for such model of democracy and the ideas on which it is founded, because these ideas and values are now on mass scale threatened. And the mechanisms that have been created to defend these, including the Council of Europe and the European Union, should not be crumbled from inside, but should be strengthened. And Applebaum is very direct in her book about the way how democracies have helped autocracy incorporated to become stronger. It's, for example, a story about the trade relations between the Soviet Union and West Germany and the dependence of Europe from Russian gas. This dependence would have been even greater unless trade sanctions imposed by United States administration on the Soviet Union. These episodes are very important to understand also how the Baltic states regained their independence. Of course, I'm not going to speak about this. Applebaum is very harsh when she writes that while Western leaders were speaking about democracy and supremacy of law in Russia, Western companies and financial institutions helped Putin's Russia to reinforce autocracy and lack of rights, and not only in Russia. She also analyzes the building of Nord Stream 2 in the Baltic Sea, and she describes the purpose of Russia. Russia wanted to promote kleptocracy in Germany and to create foundations for Russia's dominance over Ukraine. Russian gas would be sent directly to Germany, and thus cutting off Poland and Ukraine from profitable transit transactions. Ukraine had already been blackmailed by Russia with gas prices in 2014, and also before that. And Nord Stream turned into a launching pad for companies, including Gazprom, getting into the political and cultural environment in Germany. The greatest mistake was that Nord Stream project was not stopped after occupation of Crimea in 2014, which served as a green light for what we are going through today.
And let me quote, over-reliance on trade with Russia, China, and other autocracies and dependence on their corporate money created not only economic risks, they are existential. After Russia's full-scale invasion of Ukraine, Western leaders have experienced the high price of dependence on Russian gas. The transition to more expensive energy sources has caused inflation. Inflation, in turn, fuels discontent among the people. This is exploited by Russia's disinformation campaign, which is fertile ground for radical undemocratic forces in Europe. That is how she describes the current situation, and we have an existential dilemma both here in Europe and the United States. What I mean is whether constitutional instruments, courts or tools, courts in particular, law enforcement agencies, independent agencies, and free will withstand this enormous and cunning pressure of the autocracy incorporated, not only coming from inside, but especially coming from within. Let's not be naive. We have to recognize that autocracy has infiltrated democracies, including Latvian democracy, both in direct and indirect ways. And now let me talk about the responsibility of the judicial branch. The judicial branch alone will not be able to safeguard fully our democracies. Without independent and competent courts, other actors in the democracy will not be able to preserve the democracy. Democracy is as strong as everyone working for the democracy. Although we might not be on the same page and have disputes, we are able to come at the common solution, and I'd like to underline, for the sake of common benefit and common interests. The court cannot be naive. Democratic world for a long time has been both naive, compromising its integrity for the sake of economic benefits, and that's the vulnerability of democracy. Court must be able, when it comes to state aid disputes and fair competition, freedom of press, speech, and coherence of the laws to the constitution, see whether we can see the common benefit in those discussions, or is it just an attempt to defend some personal narrow interests. The court can expand the application of rights and freedoms of an individual. And I have always claimed that the more freedom we have, the more democratic we are, even though it might seem that it goes against any of our deeper instincts. However, the demand for those rights must be based in good faith, and good faith can be only analyzed against constitutional values that are harmonized to international treaties, including also the European Convention on Human Rights. In our legal system, in Latvian legal system, and in our legal system as part of the European legal space, we have the instruments and tools to respond to attempts to challenge democracy. Also in case of particular proceedings, we must therefore first and foremost check whether laws serve democratic political values. And that's why any applications or any constitutional claims to the Constitutional Court, when reviewed, need to be reviewed from the perspective of democratic instruments and tools, and whether a court can support democracy like democracy is supporting the court. And I also believe that the courts can contribute indeed to the strengthening of the democracy in Latvia, also through the laws, and the President of the Supreme Court also underlined that and urged us to focus on that in his opening remarks at the morning. So that's why the Protocol 16 was so crucial for us in the adoption of it. So congratulations indeed to our parliamentarians who adopted or ticked this away. The ratification of the Protocol 16 will allow us to ask for the advisory statement from the European Court of Human Rights while the case is still in either Constitutional Court or the Supreme Court. I do suppose that both of the courts are still, working on launching the Protocol 16 mechanisms, so trying to work out how to provide for a proper application of this protocol. So this dialogue is important for the strengthening of the judicial branch in Latvia. It is also crucial for the judicial solidarity within Europe. Our individual understanding of the quality of the democracy should be evaluated from the perspective of the overall European legal system. Therefore, the preliminary ruling request to the European CGEU is one of the factors that strengthens democracy, because it provides a uniform understanding of the European legal space on such matters as, for example, migration, free movement of capital, and money laundering. Looking at the cases that are brought before the Constitutional Court and the preliminary ruling requests from our judicial system, I can say that there are very few issues that are directly linked to the democracy. Most of the questions that are being raised are being addressed too literally or too narrowly, if I may say so. Therefore, I would like to urge the judges, and this is the time when we need to step up our responsibility and accountability. We have to look at particular cases from a broader perspective, from the perspective of efficiently functioning democracy, from the perspective of a democratic country. I know that you depend on the participants, that a lot depends on the participants and parties to the case, and the willingness of the parties to protect their rights. Nevertheless, the engagement or the empowerment of people very much relies on how confident or how much they trust the courts and the system, or in other words, whether they believe that their rights will be fully respected. And that, to a large extent, is also a matter where communication from the court is very important. So building walls and isolation that we see in the democratic world, us being focused too much on ourselves, which protects us against the outside world, can be accepted when there is a war, but it shouldn't be expected when there are powers trying to undermine our democratic values. By sticking to our own interests, isolating ourselves will not benefit the EU democracy, that is, democratic system that is based on the convention and relies on the synergy between national laws and EU laws and the general principles that are enshrined in those laws, as well as principles that are enshrined in the convention, need to be applied. They need to be operational, and operationalizing them is the task that is on the shoulders of the EU judges. We need to align their judgments to the ECHR judgments and case law and CGEU case law and judgments, and that's why both European courts have such a rigorous case law that has been mentioned a number of times with respect to the independence and impartiality of national courts, and they have very carefully scrutinized how those courts are operating, how judicial system works, how judicial branch works, and whether it creates additional trust in people to the impartiality of the court's CGU and ECtHR case law. And this is only one of the cases that I would like to mention regarding the disciplinary penalties or proceedings against judges. Both courts, when it comes to the disciplinary liability, have underlined that such a mechanism should not lead to political control over the judgments of judges. Both European courts have supported each other's views, indicating that if a state initiates disciplinary proceedings, public confidence in the functioning and independence of the judiciary is at stake. In a democratic state, this confidence guarantees the very existence of the rule of law, the end of quote. Both European courts actually guard every one of us as national court laws, and they also provide for the efficient protection of the rights of citizens. That is the very essence of the democratic system in Europe. Fair and impartial, objective courts should never give us any surprises, and procedural and rather formal approach, contrary to the United States, has proven to be more successful because we in Europe have this particular selection procedure for the judges. We have very clear requirements as to what the competence of judges should be. Such a European approach towards the competencies of the judges is where the strength of the rule of law actually lies. And let me conclude by saying this. The judicial system and every judge must be aware that we are the last hurdle, the last wall, or the last line of defense in the war against democracy, and we must devote all resources to avoid any breaches. Thank you.
Liels paldies Inetai Ziemelai par
Thank you, Madam Ziemeler, for the keynote speech, and I do suppose that this keynote speech gave us a very good context, especially given today's topic, the convention and the right to fair trial. This gave us a broader context of sort of the field on which we are, and thank you for reminding us that courts are also responsible for defending democracy. And it was very nice to hear from you that each of the cases, no matter how mundane it is, deserves a more thorough consideration from us, and we should view it through the perspective of the European democracy, although it's a very small case, mundane case. Now, let's go back to the third panel, and let's go back to our main topic of the right to fair trial. And this panel will focus on trends and perspectives. Sanita OSIPOVA already touched upon this issue, mentioning that courts date way back to ancient times, and court proceedings or the principles for the proceedings were established a long time ago. Nevertheless, they have been, meanwhile, developing and continue to develop as we speak. COVID has also triggered another phase of development, and digital challenges have also triggered another developments when it comes to proceedings. And in this panel, we are going to take a look at the right to fair trial from different perspectives. And I dare say that this panel also reveal the sort of the legal passion or the themes that we are very passionate as lawyers. And as first, I would like to give the floor to the President of the Supreme Administrative Court of Finland, Kari Kusiniemi. And as we can see, our Finnish colleague is going to talk about justice, access to justice in environmental matters and the role of NGOs. So this very nicely actually shows what he's passionate about, in fact, that he has developed not only as a judge, but as also an academic scholar. Please, the floor is yours.
Thank you, Madam Chair, distinguished colleagues. It's great to be here in the beautiful Riga, in the splendid small guild, to celebrate the double anniversary with old and new friends. And my topic, as Madam Chair just told, is access to justice in environmental matters, with a special reference to NGOs. And given the time frame I have, I can just give a kind of a superficial overview of some trends and developments on the matter. And by way of introduction, I would start with saying that access to justice is one of the very basic elements of the rule of law, because there can be no fair trial or a trial at all without access to a court of law. No substantive rights can be effectively realized without access to an independent, impartial court. And here I link to what Ineta Zimele was saying in the very end of her excellent presentation. This implies that access to justice is a necessary means to safeguard one of the cornerstones of the rule of law, that is the protection of fundamental rights as the material dimension of the rule of law. That is the thick concept of the rule of law. There are different approaches to conceptualize environmental rights. The anthropocentric view departs from the positivistic idea that legal order only provides rights and obligations to human beings, whereas the ecocentric approach holds that nature as such and or natural objects, animals, rivers, whatever, may have rights of their own. Be it as it may, in both cases, it's vital that there is someone to speak for nature or for the protection of the environment. In environmental cases, typically, for instance, persons like neighbors or those living in the vicinity of an environmental polluting installation, they have standing and can speak for their own right. But quite often they are also entitled to speak for nature or environmental rights in a wider sense. But then also authorities in certain legal orders whose task is to protect public interests linked to the environment, such as nature protection, fisheries, public health, may have locus standi. But nowadays, more often also private law organizations, associations, foundations may speak for nature. Locus standi may be established in the national constitution and legislation, international agreements, EU law, and case law at the above-mentioned levels. At present, the role of environmental NGOs as guardians of general or common environmental interests is significant. They play an important role both internationally and nationally in safeguarding both present and future generations' rights to a decent environment. The Aarhus Convention on Access to Information, Public Participation and Decision-Making, and Access to Justice in Environmental Matters, a very complicated name, is the leading international agreement on environmental democracy. Being a multinational human rights treaty, the Convention protects every person's rights to live in a healthy environment. The provisions concerning access to justice, the pillar number 3 of the Convention, provide public's right to review by a court that public authorities respect the rights to access to information, public participation, and environmental law in general. The EU Public Participation Directive from 2003 provides for public participation, no wonder, with respect to formulating certain plans and programs relating to the environment. provisions on public participation in environmental decision-making are also found in a number of environmental directives, such as the Environmental Impact Assessment Directive. But there's no directive specifically dedicated to access to justice in EU member states, which would apply horizontally in all sectors. However, the Court of Justice of the European Union has developed extensive jurisprudence on the subject. In addition, there's a growing number of provisions on access to justice in new and revised EU law. One of the paradigm cases was the Slovak Brown Bear case, where the Grand Chamber of the Court of Justice opined that by virtue of the interpretative effect of the Aarhus Convention, Article 9, Paragraph 3, an NGO shall be able to challenge before a court a decision taken in administrative procedure liable to be contrary to EU environmental law. In the European Convention of Human Rights, which now celebrates its anniversary too, there are no specific provisions on environmental human rights, but established case law of the European Court of Human Rights has recognized that the protection of private and family life in Article 8 can be extended to give protection against environmental harms such as noise from airports and noxious impacts from landfills or industrial sites. Here, of course, we all notice the Grand Chamber judgment from April 2024 in case of Klimaseniorineen versus Switzerland, where the association's application was successful. The court found a violation of the right to respect for private and family life and access to court in this climate litigation. Article 8 of the convention encompasses a right to effective protection by the state authorities from the serious adverse effects of climate change on lives, health, well-being, and the quality of life, the court says. The court found that Switzerland failed to comply with its positive obligations under the Convention concerning climate change, with critical gaps in establishing a relevant domestic regulatory framework, including through a carbon budget or national greenhouse gas emissions limitations. While recognizing that national authorities enjoy wide discretion concerning the implementation of legislation and measures, the court held that the Swiss authorities had not acted in time and in an appropriate way to devise, develop, and implement relevant legislation and measures in this case. In addition, the court found that Article 6, Paragraph 1 of the Convention applied to the applicant association's complaint concerning effective implementation of the mitigation measures under existing domestic law. In my opinion, the European Court of Human Rights comes here very near to an actio popularis, even if the court expressly denies it, and even if the individual association's members' application was dismissed. So the association had locus standi, but the members did not. I see also here a difference between so-called altruistic NGOs and associations having, at least prima facie, an egoistic purpose. Here, the association Klimaseniorinen's application was based on protecting the members' health, even though a successful application naturally would benefit people in general and also outside Switzerland. But all in all, at least in Finland, the judgment has led to an extended interpretation of admissibility of actions by the government. The appeals by several NGOs claiming that the government, the Finnish government namely, had neglected to intensify climate protection measures were examined by the Supreme Administrative Court through, even though they were disallowed in ultima analysi. This was the fact even that established case law in comparable situations would have resulted in the dismissal of the appeals. So we are a very law-abiding nation, and we very carefully read the decisions and judgments by the European courts. So, in several constitutions around the world, there are provisions concerning environmental fundamental rights. Just as an example, I would like to quote the Finnish Constitution, Section 20. It reads, "Nature and its biodiversity, the environment, and the national heritage are the responsibility for everyone." Notice the responsibility for everyone. "The public authorities shall endeavor to guarantee for everyone the right to a healthy environment and for everyone the possibility to influence the decisions that concern their own living environment." Intentionally, the provision entails no right to a healthy environment. With regard to locus standi, the second paragraph proclaiming the constitutional task to develop opportunities to speak for nature also has had a major interpretative relevance. In the case law of the Supreme Administrative Court of Finland, NGOs have been afforded standing extremely widely, even if the legislation would not have expressis verbis provided locus standi for these associations. In these judgments of the court, in addition to the national constitution, the Aarhus Convention and case law of the Court of Justice of the European Union have been extensively referred to. So, to sum up, it goes without saying that, at least in Finland, the role of environmental organizations as watchdogs and guardians of nature has been important. They have been able to challenge decisions made by environmental authorities, and by accessing the court, for instance, made it possible for the court to refer the case to Luxembourg for preliminary ruling, and more generally to ascertain that the national legislation and its interpretation are compatible with EU law. But, as always, the coin has two sides. In Finland, the criteria for an NGO to have locus standi are wide, as I just told. There is no restriction as to the number of members or the time for operating of the NGO to have locus standi. The association must only be registered and operative in the relevant area and have in its bylaws provisions of the goal to protect the nature, or something like that. Hunting of large carnivores, especially hunting for population management purposes, is right now a hot potato in Finland. The Supreme Administrative Court's rigid interpretation based on CJEU preliminary ruling in a case Tapiola has been criticized in Finland. And later, the hunting legislation has been amended to make it easier to control, for instance, large population of brown bears. Based on new provisions, the hunting authority granted licenses to kill some 130 bears in eastern Finland. An NGO, the same Tapiola, appealed against the decisions in the regional administrative court, which issued an interim order to suspend the licenses. In effect, this will result in quashing of the licenses because the court will not be able to decide the cases before the license expires. And according to the Finnish Administrative Judicial Procedure Act, an interim measure, its legality cannot be tested separately, but only in connection with the final judgment of the competent court. In media, and above all among politicians, the situation has raised understandable criticism. By lodging an appeal with a claim to suspend, the NGO can prevent hunting. The regrettable situation has even led to demands that courts should be excluded from the whole system, which I have obviously opposed firmly by referring to the very basic principles of the rule of law and court control of the legality of administrative decision-making. However, I must admit that the present situation is far from satisfactory. I see here a considerable risk to the erosion of the rule of law and trust in courts. The hunting licenses should be granted well in advance to allow the courts to do the job properly. But one could also wish that NGOs would use their rights to challenge administrative decisions with some restraint. If not, the courts must make sure that the use of the right to appeal does not lead to a situation that is clearly counterproductive to upholding the rule of law and trust to the courts. Thank you.
Paldies par ieskatu tajā, kā
Thank you for giving us an insight into how non-governmental organizations can access courts, especially on environmental protection issues. As next, I would like to give the floor to Artūrs Kučs, the judge of the European Court of Human Rights. He was formerly also a judge of the Latvian Constitutional Court, and as the title of his intervention reveals, his legal passion is freedom of speech. So the floor is yours. Good afternoon, dear colleagues. I should say that it's nice to be home at least for a couple of days, and I would like to, from the bottom of my heart, congratulate the colleagues from the Supreme Court, the senators, on their 30th birthday, and would like to also thank the Supreme Court for also organizing the conference near the 75th anniversary of the convention, which we will celebrate not so long from now on 4th of November. Convention has an enormous role, as has been mentioned by a lot of speakers. Mr. GUÐANS also mentioned how important it was to have the Senate of the or the convention. I remember in 1990s when from the Human Rights Institute I was visiting the court, and there was quite a big reluctance to adopt the convention, and everybody was saying, do we really need the convention, because politicians can, address this more broadly than the convention intends. But a lot of progress has been made ever since, and it would deserve even a separate conference looking back at how this convention has influenced the development of the legal order and legal system in Latvia and the application of the laws. What I would like to touch upon in my today's speech, and I wouldn't say that it's my passion really, it's rather dictated by today's challenges to the democratic world, the militant or self-defending democracy, as it has developed through the European case law in the given geopolitical context, and quite often we question ourselves whether the convention is able to respond to current challenges and developments. I mean, through case law. I would like to address or mention three cases. Some of the colleagues already mentioned Gaponenko against Latvia, Ždanoka against Latvia, and Kirkoros against Lithuania, or versus Lithuania, rather. And the reasoning included there with regard to the need to democracies to defend themselves, and also the role of courts, and what the European Court of Human Rights expects from the national courts when it comes to cases like these, which are cases, I don't know whether that's a novelty, but in recent years, those cases have been quite challenging for all of us, I suppose. Briefly about that, and then I will also mention another case which is linked to the innovations in the approach of the European Court of Human Rights. And I would like to first mention the case Rodina and Borisova against Latvia, a case which was reviewed this year. So the banning of the Russian march on the Riflemen's Square to the occupation monument on 9th of May 2014, day when Russian Federation is celebrating its victory over the Nazi Germany. According to application, they wanted to protest against the reduction of the share of the Russian as tuition language in our schools. In the second case, there was appeal or a claim against the ban for the demonstration across from the Ukrainian embassy on 23rd of September 2014 to stop the war in the southeastern Ukraine shortly after the invasion of Ukraine, and also the occupation of parts of Ukraine. So Latvian security services and administrative court detailed and analyzed the circumstances and the national security threats, given that Russia has invaded Crimea and annexed it, and has also invaded eastern Ukraine 2014. Although in 2014, the 9th of May march was banned, although previously in 2013 it was allowed. So the court looked at the geopolitical context, which has had an influence on the national security of Latvia, and also incitements to armed resistance, and also use of the Soviet and Donetsk Republic symbols, and also the national court underlined. I will not go into detail, but they expressed doubts about the true purpose of this event and whether the applicants will indeed, protest against the education reform. So that was quite doubtful, really. One of the organizers of this event was, by the way, accused, and it was publicly known that he took part in the Russian-supported military activities in Ukraine. So the European Court of Human Rights reviewed both cases and conducted a detailed security risk assessment that was conducted by the administrative courts, and found no violations, and pointed out that considering the historic experience of Latvia in current geopolitical context, public bodies had the right to consider that political activities that are openly supporting Russian Federation might threaten the national security and democratic stability in Latvia. Court also underlined that in a democratic society, we've talked a lot today about democracy. In a democratic society, we shouldn't accept the claims that put one nation above another nation, or support aggressive war propaganda that supports separatist groups in eastern Ukraine that have not been recognized internationally. Would like to also underline that European Court of Human Rights and national courts had different opinion on one of the aspects, not major differences, so there were no violations, but there were methodological differences. National courts referred to the Article 17 of the Convention, which says that abuse of rights are not subject to the protections of the Convention. and European Court of Human Rights did not agree to such application of the Article 17, and the proportionality, according to ECHR, stems from the Article 10 and 11 of the Convention. So with the Article 17, paragraph 17 in the back of the mind, nevertheless, going through the proportionality test, they concluded that it complies with Article 10 and 11. We could have a debate about the second case and the second statement supporting the Russian aggression because, for example, UN International Pact about the civic political rights, Article 20 requires countries to not only provide but also act against any aggressive propaganda of war. And we can see that actually, according to ECHR, it's very cautious when it comes to application of Article 17. And we can perfectly understand that because they are trying to prevent a more broader application of this article, or rather abuse. So for the national courts to avoid violating the convention, they need to conduct a full proportionality test, except for cases where there are clear incitements to violence. So in the rest of the cases, it is very important to have the proportionality test. And although there was a reference to Article 17, Latvia did conduct a proper or full proportionality test, and then this leads to a dialogue because then ECHR can actually look into what the national courts have analyzed, and they can say, you know, you have looked at this too narrowly, or such statements are beyond the scope of the convention, and if the court would not agree, that then it would be a clear violation because they have nothing to support it with. Why, for example, national court after the proportionality test has concluded this. And another case, and I promised our moderator to not abuse time given to me, is linked to the changing importance of the symbols. I'm talking about last year's case of Bozic against Ukraine, and ECHR dismissed the claim of the applicant regarding the ban on use of St. George's ribbon. It was a former military commander who was in the Soviet army, then switched to the Ukrainian army, and he mentioned that his grandfather, father, and father's brothers have fought in the Second World War, and for him, wearing a St. George's ribbon on 9th of May is paying tribute and commemorating his relatives, and it's not linked to, and I will not go into detail, but there was a very thorough analysis of how St. George's ribbon originated historically and how its use nowadays has changed, how this symbolic notion has evolved through times, and what it means to people who have suffered from the Russian aggression in Ukraine, the victims in Ukraine. You know, somebody wearing such a symbol publicly or such a ribbon publicly is very painful to them, and court concluded that the use of St. George's ribbon, considering the Russian aggressive invasion of Ukraine, can be considered a political statement and a support of the aggression, and that's why state can limit the use of such symbols in its on its territory to defend the public order and protect the public order and democracy. And third case, which is a rather sort of fresh case, but already outlines how we should approach the much debated issue of threats to democracy and electoral freedoms. I'm talking about Bradshaw against the United and others against the United Kingdom. And in this case, ECHR was very cautious, made a very, very cautious little step, but nevertheless quite firm step towards a decision where states can not only refrain, but can also make steps to defend free and fair elections. Several British MPs complained that the government has not done enough, hasn't investigated properly, and the legal framework is insufficient to deter Russia's disinformation campaign and meddling with the 2019 parliamentary elections in the UK. According to applicant, the state has violated Convention's Article 3 of Protocol 1, right to free elections. And this actually highlighted several complex issues, and Kari already outlined when talking about environmental rights. Who can complain? Who has the right to complain? Submit a complaint. And these MPs were elected officials who were elected to the parliament, to the legislature. So the question is, who's the victim in this case? And the approach of court was rather very much open-minded. The court established that any voter, it's any voter's concern, any voter's rights have been infringed. And you had to also prove that meddling has been so intense that it has indeed influenced the choice of voters. And also there was a question whether courts can actually review cases like these. We had quite an intense debate regarding Romania's constitutional court decision, which actually revoked the election results, and similar discussion should be had in Latvia. I don't know what would happen in our case. I mean, we are not facing a situation like that, but our courts might also come across cases when there is a massive meddling with, or manipulation with the election results.
The Supreme Court of the United Kingdom had dismissed this complaint of the applicants, arguing that this was a matter in the competence of the parliament and not a matter of courts, and that no obligation, positive obligation followed from Article 3 of the first protocol to the convention. The European Court of Human Rights did not dismiss this application. It was admitted, and it recognized that the state had the obligation to take active steps to defend the integrity of elections, including against interference and campaigns of foreign countries. But the court recognized that the United Kingdom had taken sufficient measures, and that the convention did not impose the obligation to ensure a specific result in protecting integrity of elections, but that the state must take reasonable measures to protect democratic institutions. So it is important to show, and the United Kingdom did show, that a number of measures had been taken by the government after also following the reports on interference by Russia, and also the legal regulation was improved. So the states must implement active measures to diminish risks to democracy, prevent foreign interference, and investigate such cases. To conclude, the case law of the European Court of Human Rights shows that human rights are not operating in vacuum. We see the situation, we see what's happening outside the window, we see the geopolitical context and the new challenges. And also we see the need for protecting democracy. And as I said, the convention imposes positive obligations upon the states to take active measures in protecting democracy. However, when restrictions on human rights are imposed, the necessity and proportionality of the restriction must be reviewed. And the assessment and reasoning of the national courts are fundamental in this process. They are close to the specific society. They understand the risks and also they know the historical background. But speaking about the dialogue, the assessment or lack of the national courts will have an impact upon the outcome of the case at the European Court of Human Rights. Thank you. Thank you for this insight into different cases linked to the freedom of speech, freedom of will. But now we come back to different procedural aspects. And our next speaker is Andris Laviņš. Currently, he is the judge at the Supreme Court of Latvia, but he has been the judge and the president of the Constitutional Court. And I have to add that Andris Laviņš was the first president of the Regional Administrative Court. And again, my subjective view, but I believe that Aldis Laviņš is passionate about civil proceedings and procedural rights. Thank you, Anita, for these wonderful introductions. Dear colleagues, I'm indeed very happy to share my reflections during this anniversary conference. And I will speak about the trends that can be observed in Europe with respect to improving the functions of a cassation court over time. I believe that everything in life keeps changing, including the law. And also in the area of cassation functions, we need certain changes. And while we are now celebrating anniversaries, and usually we also try to take a peek into the future, I would like to try to understand what aspects of competence the Latvian Cassation Court might discuss, not introduce. I don't want to rush. And I will immediately start by saying that these models of Supreme Courts are very different. I will not speak about the Scandinavian model and also the systems that have developed under the influence of German and Austrian legal system. I will speak about what I have seen and researched in those countries where Supreme Courts act according to the cassation principle. 15 minutes is a very short time, so I will start speaking about the first aspect. So what observations are? The circle of countries is quite extensive. Starting with France, which really founded these cassation principles, and Lithuania, Estonia, our neighboring countries, Poland, and other countries in which the competence of the Supreme Court has the following one: to revoke the judgment under review, and instead of that, deliver a new judgment on its merits. It's revoking, not transferring for re-examination to a lower instance court, but to replace the judgment of the appellate court. This might seem a utopian idea. This does not really comply with the principle of cassation, perhaps. But I will immediately point to the main criteria when such competence could be exercised. And actually, we can read this from the civil procedural administrative regulation on the civil, administrative, and criminal procedure. First of all, this can be done if the court of lower instance has not made significant procedural violations, and the case does not involve disputes on facts. So there's only the legal matter. The court has made mistakes in applying legal provisions, or it has interpreted a provision of substantive law erroneously, or the facts have been provided erroneous legal assessment. The Supreme Court can say it itself. We can do it and just complete the case. And these are cumulative. All these three criteria must be met in order to implement this competence. What are the benefits? We are celebrating not only the 30th anniversary of the Senate, but also the 75th anniversary of the Convention. So I want to bring in fundamental and human rights into this story. What we see in the courts, problems in access to court, long proceedings. All this points to problems in respecting human rights, then not abiding by procedural safeguards. And I wanted to look from this perspective whether these new competences comply with the standards regarding the right to a fair trial set in the Convention. So I wanted to point out the benefits, but we also have to look at the possible risks. And here the risk would be limited possibilities of appeal. If the Senate, the first instance and the second instance, have adopted one decision on satisfying the claim, and Senate arrives at the decision that the legal matter has been adjudicated incorrectly. So, but then the question is where to appeal against it. That's impossible, but the standard of human rights demands this. So these are matters to be discussed. I just wanted to identify this risk. Of course, a written procedure can restrict the possibility of hearing the parties. In a situation which I described, this risk exists. Also, the risk of insufficient verification of facts is possible. And here we have to speak about the case on its merits. So we are not just responding to the arguments of cassation appeal, but we must provide additional reasoning, and we have to explain how we understand the law. I felt that at the end of the day, you might already feel tired, and I thought illustrations would serve some purpose. So, dear colleagues, as an illustration, I wanted to show the historical sort of view the 13th century cassation, and on the web page of the French Cassation Court, you see a wonderful description of the King Saint Louis after attending the church. He goes to JELIČ, and he asks the people whether his intention has been reflected in the laws of the parliament. He says, and here we have cassation, this has to be revoked. The king needed cassation to supervise the lawfulness of his decisions. He wanted to reinforce his power. And now we see, well, the background is still France, but we have a present-day judge and the parties in the case. Do we really want to step into the shoes of a king? Do we want to safeguard some power? If we have these preconditions, then why modern cassation instance could not put a stop to the case and end the case? When in 2017 I was on a working visit to the Lithuanian Supreme Court, colleagues said that this could be approximately 10 cases annually, even out of 100. But these are 10 cases in which the cassation instance shows its maximum effectiveness. This effectiveness is not meant only for us, but effectiveness for the citizen. And if the citizen is satisfied with the way the judicial system functions in his country, then actually in a simple civil case, we can create this feeling that citizens, society understands the need for us. They understand that we can be trusted. And so if judicial power is trusted, then we will always be protected and defended when we are under threat. So I was looking for all those elements and possibilities for increasing public trust in the judicial power. Now the second competence. That also comes from Lithuanian and Estonian civil procedures. We have them. I didn't find it in the French civil procedure or elsewhere. This year I had the possibility to go to the Netherlands, and they do not have a competence like this, but our neighboring countries have this. So, if there are no objections to facts in the cassation complaint and no dispute regarding legal matters, and if the procedure in the first instance has respected the right to a fair trial, then in the cassation complaint, if we see that the judgment of the appellate instance is wrong, but the judgment by the first instance court was correct, then we should give the legal force to the judgment by the first instance court. So the benefits of this. I believe that we have resolved the case without transferring it for re-examination. It's our effectiveness, and it also highlights the importance of the first instance. And in addition to what the president also of the Supreme Court has said, that all legal issues should be resolved before the first instance court. So this would be one of the mechanisms for increasing the significance of the first instance court, and also promote trust in the first instance and quality of the court's work. Of course, we have certain risks. The burden of the cassation court would increase. We would have to review judgments by two courts. And the party who had a positive outcome at the appeals court might have this feeling of unfairness. So while the first instance court's judgment was deemed to be effective, and now we really, I believe, actually, that artificial intelligence is coming at the right time. So actually, we see these pictures. These are the outcome of my personal relationship with artificial intelligence. I gave this information about this competence, and of course, you have to talk to the artificial intelligence. And finally, I liked this one. The Senate is moving this compass of justice where it should be. And sometimes the sort of solutions found by the first instance and appellate is opposite, and we have the possibility to move it in the most appropriate way. And now the third competence.
It is not too common. I would say that none of the Baltic countries has it, neither Lithuania or Estonia, but we can see it in the Netherlands, France, Romania, and Poland. The competence or the right to take the advisory judgments or preliminary rulings. The preconditions are rather different. Lower instance case, the courts can review the cases regarding the same complaint or issue, or it can for example, review the contested legal requirements because these cases are not referred to the cassation court. This is an instrument how those countries, or this is the way how those countries have addressed these rather complex judicial issues. And yesterday I talked to my colleague in Lithuania, and she mentioned a wonderful example from the Dutch court, Supreme Court. And let's look at this example now together with you. It's a very, I would say, a contradictory example. So it's COVID, restrictions, SMEs under the restrictions are under duress, and they are asking, for the lease discounts, but there are no rebates, and there are a lot of appeals in the court. One first instance court decides one way, another one decides another way. Isn't this the right moment, or a very good example where, for example, advisory judgment might be a very good solution and a very clear signal from the Supreme Court to the society, us jumping in and contributing when there is a lot of uncertainty. Hundreds and even thousands of enterprises have questions. Can we get a rebate? Can we get a real estate rebate or discount, which was very essential for them under the COVID restrictions? We didn't have, a ready-made solution for that. First instance courts, dealt with it the best they could. 1.5 years for the appeal procedures. It's 2023, 2024. The COVID is long over. And what has happened to those enterprises? Half of them are closed, shut down. Our economy has suffered from that. Why shouldn't we have a tool like that or a solution like that? I've prepared another one, but I have only 1 minute to go, and unfortunately I will not be able to also analyze other examples. But this was a rather vivid example of conceptual choices that we have ahead of us. So it both has its pros and cons. So lower instance courts can apply the legal requirements uniformly, if they would be able to establish whether that is necessary or not. It would reduce any differences in bench practices in long run. I would believe that also the Senate would benefit. They would have less cases. Their caseload would reduce, and it would also strengthen the dialogue between the society and and would benefit the economy. What are the risks? Well, the caseload would increase for the Senate, and there are a lot of uncertainties. And I asked the Dutch colleagues, we are no worse than Dutch colleagues. We are also legal professionals. We're also lawyers, and they said it's not a problem to resolve this. If you need additional information, you just request additional information from the court that reviewed the case initially. So there is no problem there. And it may be perceived, this is an interesting, actually, perspective, it may be perceived as a binding obligation that might impede the independence of the judges. And it's the Lithuanian example. Lithuanians can provide advisory interpretation of legal norms, but that has been found in conflict with the judges' competences. I don't know if the same thing concerns Latvia. We also talked about the Supreme Court judge's decision, which was found unconstitutional. But I don't know whether these advisory statements would be found unconstitutional. But we have this Lithuanian example that all of us have to be aware of, in fact. And what did the AI tell me about this competence? Well, Supreme Court has this advisory channel that is on air, and you can see the Supreme Court judge beaming with happiness and being able to support his fellow judges who are listening through the good old radio, the findings and conclusions of the Supreme Court judge. To sum it up, new competences would provide uniform case law as well as contribute to the efficiency of the judicial system. The main challenge to me, however, is not to go into the other extreme. We need to reconcile efficiency and fairness. Because of procedural guarantees, justice should not suffer just because Senate wants to deal with the matter faster. That shouldn't be done this way. And this is definitely an opportunity to strengthen the people's trust in judicial branch. However, as I already mentioned, these new competences need to be applied wisely and cautiously. Colleagues, as I said in the beginning, our life is changing rapidly, but the Civil Procedure Law 1714 article has never changed. The only thing that has changed is that you can repeal the judgment and bring it back to the first instance court. Is it good or bad? Well, it's up to you to decide. Everything that I mentioned in my slides is non-binding. It's not a full story. We have to think for ourselves. We don't have to blindly follow the example of the others. We are the makers of our system, the system that fits best the Latvian specific situation and our interests and would strengthen the trust of the people in our courts. If we'll manage to achieve that, we will indeed the bastion behind the democracy that will always protect it. And Godspeed to all of us in that. Thank you. Thank you for a rather passionate introduction to hopefully a discussion on expounding the competences of the Supreme Court. This is actually concludes the last panel with trends and perspectives. I'd like to once again thank all the speakers. According to our agenda, we only have the closing of the conference to still deal with. The president of the Supreme Court, Mr. STRUPIŠS, will provide the closing. But before that, we will have the summary of the conference from LÍBINA-EGNERE. So, dear speakers, thank you once again. So, ladies and gentlemen, it's now my honor and pleasure to give floor to LÍBINA-EGNERE, who's the advisor to the President of Latvia on legislation and international treaties and international laws. But we invited Kristīna not as an advisor to the President. we actually invited her as somebody who has worked for many years in the diplomatic service of our country, and most of her time in the diplomatic service she served as the representative or the special envoy of the Cabinet of Ministers in the international human rights organizations and the Civil Court of Human Rights. So the convention has been a major part of her professional life, her everyday sort of guide and her everyday concern. At least from the Latvian perspective. And it's over to you, Christine, for the recap of the conference. Dear friends, I'm very happy to be here. I'm very happy to meet many of my old colleagues, and I was very happy to meet many new friends. I'm one of the few lawyers who's not a judge, so I'm like a bat between birds. We are both flying, but are slightly differently. But as Anita mentioned, for many years, I thought that I'm a friend of courts, of international courts and national courts here in Latvia. So I'm absolutely honored to provide the recap or the summary of the conference. Well, all the speakers were rather disciplined, prompt, and approached their responsibilities very responsibly and talked from different perspectives how the rights to a fair trial apply to them and their bench practices. You approached this right from both through a microscope and a telescope. You both looked at minor nuances and details and also tried to paint a broader picture as well. We had a rather dense discussion, and the takeaways and findings that we are going to be taking away from this conference are rather broad and very diverse and colorful. Each of us could draw something that we personally value higher from this conference. What I'm going to offer to you in form or shape of takeaways is takeaways in three main categories, which are linked to the title of the conference: who, how, and for what. So, right to fair trial. Several speakers address the right to fair trial from different elements that you can see in all trials. So nobody talked about criminal proceedings being different to civil proceedings. Nobody discriminated between different instance courts. Everyone talked about right to fair trial and its elements throughout different proceedings, public access, uniformity, coherence, conformity, and reasonable reasoning and also resilience and keeping up with times, and courts need to develop along the other social processes, but this development should be chaotic. So these elements are the common denominators in all the speeches, and what's important is that speakers also explained why these elements are so crucial or integral. They are so important because reasoning, because justification and openness of court judgments actually strengthens the trust and legitimacy of the judgments and judicial branch, and it also encourages the participants and the society in general to comply with the judgments of the courts. So, answering the question, who has the right to fair trial? So there were these elements that we saw in all of these speeches. The next question is how we approach the right to fair trial and these elements, and how do courts ensure that they are complying with the right to fair trial, and to make sure that their judgments are respected, legitimate, and enforced. Speakers mentioned internal controls, for example, three-instance court system at the national level, and the dialogue between different instance courts to make sure that they are all implementing the right to fair trial. So there is an important question of openness as well. I very much enjoyed the second panel that focused on the prevailing trend nowadays of the tension. On one hand, we have an enormous data flow was subject to a lot of information, and there are a lot of people who are publishing every detail of their life on social media, whereas on the other side of the spectrum you have the privacy protection, personal data protection, and sometimes these two extremes, they collide, they clash, and quite often this clash manifests itself also in the court judgments and the adjudication as a process. And also in this today's title, we have this important notion of the dialogue between the three instance courts nationally, but also between the national courts, supranational courts, and international courts. And court dialogue is a respectful way of exchanging experiences, opinions, and sometimes even criticizing each other. And last but not least, why we have this debate about the right to fair trial, the dialogue between courts, and the power of the courts or the judicial power. Introductory remarks already mentioned some of the challenges we are facing nowadays, and I think that you will agree with me when I'll say that each age believes, or each generation believes, that it is facing unprecedented and challenges that have never been experienced before. But each new generation has to be able to detect and identify challenges to at least be able to classify those challenges.
Because there are challenges which I believe are inevitable in the course of evolution and progress of society. These are the so-called new realities, which we have just to accept as logical. Speakers mentioned digitalization, the use of artificial intelligence systems. These are the realities that we have to take into account, and we have to adjust to them reasonably. But then we have another group of challenges, which I am going to call threats. These, we also heard about them in the presentations of several speakers. Threats to where we live and threats to the way we live. Threats to where we live. We heard about these in the presentation by our Finnish colleague. We are speaking about environment and climate. During recent years, the climate change issues and the impact upon individuals have reached courts, in particular in courts. And I see this as an indicator that this is such a painful matter that assistance is sought before courts. If you can find resolution in discussions or conversations, people won't spend their effort and energy by going to courts. But now we have the International Court in The Hague and Human Rights Court and and the Court of European Union have been forced to take up these matters of climate change. Of course, on the national level, the standing of NGOs before courts is also an important matter. But we also threats to our way of living, the way we live in society, in our environment. And I believe that here we see one very important aspect: threats to the rule of law, a threat to the state order, lawful state order. And here again, we saw several aspects. A threat to the rule of law and democratic state order is abuse of human rights. Article 17 of the convention was referred to, which prohibits abuse of human rights. But probably in your own practice, you have encountered such situations where you ask this question, whether the rights granted by democracy are used for democratic purposes or for undermining democracy. Another essential threat to the rule of law and democracy is accusing human rights, that human rights somehow prohibit protecting the national security, that somehow human rights prohibits us from preventing crime and preventing instrumentalization of migration. And I believe this is just using human rights as pretext to avoid really painful topics. But throughout the conference, I saw one clear message being outlined, and that was about the very important and sometimes decisive role of courts in identifying these threats and also preventing these. The courts will be the institutions that will also review the matter of alleged abuse of rights. The courts also may explain admissible restrictions on human rights in order to reach aims that are important for national security. And indeed, the courts are the very last and the strongest bastion in guarding democracy. So the courts and the judges have huge responsibilities. And in the interests of democracy, in the interest of our survival, we should ensure that the courts are able and they can ensure this responsibility. This means education of judges, guarantees for the independence of judges, so that the court would not be afraid to say in a democratic state that the moment has come when solutions that have been chosen turn into threats. And sometimes courts can also tell how the state could overcome its challenges. I would like to thank all the participants, all the speakers for this very interesting discussion. I have still many notes, but I believe we are approaching the end of our conversation, the end of our conference. I'll just like to highlight once again my main finding. Without courts, without independent and strong courts, it is impossible to maintain a truly democratic state order. But the states likewise cannot exist without a truly democratic state order. Thank you. I'm not going to introduce myself, and no one is going to introduce me. I would say that the quality of the conference is characterized by the fact that the time stopped inside the room. And this stopping of time, well, we see that no one is looking into their watches, and even when they overuse the time, and when the lunchtime comes, no one is running to the door to go to lunch. And according to these criteria, the conference has been very, very successful. The questions, the topics that we discussed today, these are not new. These have been discussed for many times, but they still have kept the relevance. We are still focusing on them because these are internal topics. The reasons change, but the topics remain because life keeps changing, technologies keep changing, parties to the cases are very witty, very smart. They bring new questions to the courts. The law develops, legal provisions develop. And so we are going round and round. We are dealing with seemingly the same matters, but in new quality. And the good news is that we have something to talk about, and we will have something to talk about in the future. The judicial system is united. Sometimes courts are accused of problems that are linked to justice in the state. The court has the final say. And so the court somehow accumulates all the shortcomings that had existed before the court. And the right to a fair trial, this is not only the possibility of the court to ensure it, but we have to speak about the entire system of the court, prosecutor's office, the bar, and all these other instruments, because our work, the work of courts, depend on this. And we depend on this in ensuring the right to a fair trial. We cannot ensure right to a fair trial if the prosecutor's office has not worked properly, if the advocates are not working according to the law. We really have to look at the entire system. About the Supreme Court, the Latvian Supreme Court. I have to say that I feel very satisfied that on our anniversary, we are looking for new solutions. We keep identifying problems, and we are trying to continue our development. We are doing in practice everything that was discussed today. We are improving the quality, the reasoning of our judgments, because we understand very well that without a reasoned judgment, we cannot ensure the right to a fair trial. Then uniform case law, that's our basic function. Also, we have the flood of legal provisions and information. We are dealing with it. We are developing AI tools that will help us to aggregate and analyze information. And another important matter that we are dealing with now already for 4 years, and finally we are very close to implementing it, is to separate courts from the executive power, because the system that exists in Latvia, in my opinion, and in the opinion of the Judicial Council, does not truly comply with the separation of, or the ideal model. Because the first and second instance courts, in terms of organization and financing, are subject to the Ministry of Justice. This was a mistake which was not dealt with in 2004 when Latvia acceded to the EU, because we had a concept document, draft legal acts had been prepared to separate these courts. But after acceding to the EU, all this was forgotten and shelved. But 4 years ago, we resumed this work. For the first 2 years, we lacked political support, but now for the last 2 years, it seems that we have now political support. And we are almost ready to take this draft law to the legislator to resolve this matter. Because this is also one aspect in ensuring the right to fair trial, because being subordinated to the executive power is not a good, this is not good experience. Even in those countries where traditionally courts have been under the supervision of the executive power, even in those countries we see that this separation is ongoing, trying to build institutions which separate the judicial system from the structures of the executive power. And taking into account the global development trends, this could be one of the really last moments when this should be done. Because if, as a result of political mistakes, populism will continue developing, at some point this could be too late. In Latvia specifically, this is not too late, but I see that that other countries are apparently sensing something, and they want to get ready for the worst case scenario, not to allow what happened in Poland and Hungary. It's very easy to do this. And then the right to a fair trial can be forgotten for at least some time. So the good news from the Senate is that at the age of 30, we still keep thinking, we are looking for solutions. Because otherwise, midlife crisis could set in when we reach the age of 40, but I hope that we will manage to avoid it. And to conclude, I would like to thank all of you, but in particular Artur Skuč, our colleague from the European Court of Human Rights, actually in conversation with whom this idea developed, and he helped assist us in involving judges from the European Court on Rights and also choosing the topics. Anita Kovaļevska and Jānis Plebs, senators who were very creative in developing the content of the conference. I would like to thank all moderators, all speakers, especially former President of the Supreme Court, Mr. GUļāNS, and Inese Ziemele, who apologized and left because she had to leave. And finally, I would like to thank the team from the Supreme Court's administration, professional and wonderful team. Without the support of them, we wouldn't have had such perfect organization of the event. And I would like to thank also all our wonderful guests. And by this, I close our conference, but that's not all. I invite you to informal conversations to over a glass of wine. Although we had no discussions following the presentations, we can continue our conversations and discussions downstairs. Thank you.